appellant learns about the filing of an execution petition, will be at liberty to move an application for early hearing. List also have it on 9th January.
9th January.
Yes, Mr.
Can I make only one request?
Yes.
No ex parte orders in execution, that's all. I'm only seeking protection to that extent. If I'm allowed to participate, no issue.
I can't take away the jurisdiction of that court. You please file a caveat, sir, over there, and I'm giving you that liberty that you come back.
I'm sorry, Malad.
Yes.
In execution, there won't be any caveat. That won't be maintainable. That is my only problem. Otherwise, I would not have bothered. That's all. No ex parte order.
PDA is also one of them. His execution will be filed. We will be the first online or before that. In case execution is filed and sir is of the we will not be informed. We will be before your eligible time.
The appellant is directed to serve a copy of this paper book on the contesting respondent along with a copy of this order through email.
Please, Malad.
In addition, through the counsel who represented the contesting respondent before the appellate.
I'm deeply obliged. Deeply obliged.
9th January for the roster bench.
Deeply obliged.
Item number 8.
This application, we are only seeking extension of the interim order of 24th of December to the 5 tenders mentioned in para 7. In this case, there is a blacklisting order against the petitioner. By the definition of affiliates, when we file any tender, we have to disclose whether any affiliate is being blacklisted or not. Now, my lords, if my lords will have the order of 24th of December at page 14.
Appearing for the respondent.
Yes, my lord, I am appearing for the respondent. My lord, in this case, your lordship will see that the order of blacklisting has not been varied. In fact, they have given in writing that we will accept that order. The only question is that they are now filing one application of the other to get a stay to deprive the order being effected on the affiliates. This has to be heard. Finally, it's already fixed on 16th.
Yes,
now, this idea of bringing in fresh matters they'll again file after 5 days. They'll file another.
Let me put it to them, Mr. Sangal, that how many more applications they're going to file. Let us ask them. Just let me put it to them.
No more applications. My lords will take that.
You're undertaking that you've exhausted and you will not be participating in any further tender.
The tenders before the 16th, because this is protection only till the 16th.
Right. Mr. Sangal, I'll record this statement of theirs and that they will not be participating in any further tenders before 16 January. Okay?
Well, there's one thing more. This order has been passed by Solar Energy Corporation. Now, one of the item 4, in which they want a similar order, is also the tender is issued by Solar Energy Corporation.
Just a minute. Just a minute.
Page 9, my lord, of their application.
Yes.
Yes.
If you see the 4th item, that is Solar Energy Corporation of India Limited. That is the respondent before your lordship.
Yes.
And that's the party which is issued.
We'll exclude that, sir. We'll exclude Solar Energy Corporation. Okay?
My lord, may I make another suggestion? I mean, lordship permit.
Yeah.
Lordship, confine the order to 1, 2, and 3, and let the matter be taken up in the supplementary list on 16th, so we can argue it out.
I'll do that. It will be 1, 2, 3, and 5. No.
Lords,
And 5 is also 16th. So if 16th the order is decided by your lordship one way or the other, it will
I understand, but 5 is anyways not solar energy, so we'll let it be 1, 2, 3, and 5.
Okay.
Because the filing will have to be done by then, and I'll make that direction also that it be taken up in supplementary. List. Okay?
Obliged. Will do. Obliged.
IA number CM application 7663 of 2024. This is an application filed by the petitioner seeking extension of the liberty granted with a seeking extension of the liberty and protection granted with a order dated 24 December 2024 with respect to
Para 30.
5 5 tenders enlisted at paragraph number
7.
paragraph number 7
Of
of the
application.
application. Full stop. Learned senior counsel for the respondent who appears on advance notice states that the petitioner cannot render ineffective the order dated 6 November 2024 and its undertaking dated 16 December 2024 by filing these applications. Stop. He further states that respondent is opposing the relief with respect to the project enlisted at serial number 4.
My lord, your lordship may not say that. I'll have problem with my clients. Your lordship has recorded I'm opposing, but then pass the order as you like.
He states that respondent number 4 is more specifically opposing the inclusion of the tender at serial number 4 of the table.
May I only point out one thing?
Yeah.
Because the reason why this interim order was granted is that in the earlier writ petition, my lords, where RPL had come, my lords, that order is at page 669 of the writ petition. There, my lords, a specific order was passed that the blacklisting qua RPL and its subsidiaries will not be given effect to. And the reason why this interim order was given is because the earlier interim order is virtually being put to naught because the subsidiaries of RPL are affiliates of the petitioner. So, my lords, today to say that we will not be allowed to participate in their tender, my lords,
We'll put it up on,
Let's get them.
I'll make a note that this will be taken up in the supplementary list and on that day, this issue will remain open. Okay.
My lord.
or if my lords can have then the date a day or two earlier, my lords, because the last
I
date
just
is
think the roster bench may expect this matter to be heard on 16. That's all.
Very well,
That is the only reason. You know, you may lose the date of 16th also.
very well.
We'll just direct that on 16th, it will be taken up in supplement.
My lord.
We'll specify then that this tender also issue will be taken up on 16th.
Yes, and then just take down. In response, learned senior counsel for the petitioner states on instructions that there are no further tenders. There are no further tenders on or before 16 January 2025, which the petitioner's affiliates are contemplating in participating, and therefore no further applications are intended to be filed before 16 January 2025. He states that the issue qua the tender of Solar Energy Corporation of India Limited may be deferred until 16th January 2025 and the matter be taken up in supplementary so as to enable the petitioner to urge its submissions qua this tender on the said date of hearing. Keeping in view the order dated 24th December 2024, the petitioner is hereby granted liberty to participate, petitioner's affiliates are hereby granted liberty to participate in the tenders and bids which are enlisted at CL number 1, 2, 3, and 5 of paragraph 7 of the application. The issue pertaining to the entitlement of petitioner's affiliates to participate in the bid at CL number 4 will be considered by the roster bench on 16th January 2025. Full stop. Issue notice, the counsel for the respondent accepts notice, reply if any be filed before the next date of hearing. This on 16 January 2025 in supplementary list. Yes, sir.
Your lordship may also add that this order is being passed without prejudice to rights
That
and
is already there in the
Yeah,
first.
this order
No,
is
it's earlier there, but let it be there also. I don't want them to come up.
all other terms and conditions of order dated 24 December 2024 shall apply, and the order has been passed without prejudice to the rights and contentions of the respondent.
Can we have the order Dasti? Or my lords may specify that it can be used under the digital signatures.
Okay, I'll specify.
Item number 9.
Please, my lord, I appear on behalf of the respondent number 1 NCD in this case, my lord.
Lord, my basement is being weakened and the way, my lord, the construction is going on the down floor, my lord. Shall we kindly have, my lord, the conditions of the property, my lord, on page 38.
So who's appearing for NCD?
My lord, I
Because
appear on behalf of.
He's appearing for MCD. I am for respondent to Union of India Ministers.
You're appearing for Union of India, SHO.
Policeman, yes, madam.
Sir, what is your inspection status of the
My
property?
lord, as per my instruction, my lord, on 24th of December, we have issued a notice under section 337 of DMC Act, impose a penalty of rupees 10,000. Thereafter, 27th of December, we issued a stoppage of work in view of the GRAP 3 prevailing in Delhi. So as per new instruction, my lord, we received yesterday, no construction is going on the premises, my lord.
My lord, so far as
Construction is going on.
No construction is going on. That the construction, it was not a case of the construction, it was a case of the renovation in the ground floor.
No renovation is going on.
We have issued the stoppage work on 27th of December. We will file the
And
status
when
report
is the
also.
hearing before you? Have you scheduled a hearing before you? Because the matter has to be first decided at your.
Please, my lord, what has happened, my lord? As of now, there is no
So why don't
unauthorized
you give them a hearing, sir, so that the issue
We'll do it, my
can
lord.
be.
We'll do it, my lord.
Yes. So when will you schedule a hearing with the respondent numbers 3 and 4?
My lord, it can be any day, my lord, any working day, my lord. Day after tomorrow, it can be, my lord.
Sir, the first is a working day.
Please, my lord. Yes, my lord.
First is a working day, and you'll give a hearing to petitioner also at that stage.
Please, my lord, we'll do it, my lord.
All right. Sir, please ask your policeman, has he verified? Has the renovation work stopped? Ask
My
him.
lord, renovation work has stopped, my lord. We have written to MCD also. We received a complaint. And
But has it stopped today? Bandit? So you please, you follow the work stop notice.
yes, my lord.
Sir, you schedule a hearing, you please appear before MCD
Please,
and
we'll
let
do
them decide.
just one submission, my lord, since I am not.
So let them just finish, yes.
Yes.
Anything else, sir?
Work stop notice be given to us because we should be aware. Because we can implement that.
I'll ask him to file these 3 notices on record
Yes.
and give you a copy.
Malice,
Okay?
malice.
And I'll record his submission.
Definitely, malice. So
Lord,
that
two
we-
notices.
My lord, since we don't have the.
Record that. And in your presence, I'll just pass an order, council.
My lord, as my learned friend is saying that the work stop notice has been issued by them, my lord. Just one thing I want to clarify here, my lord, is that GRAP, if it is in operation, my lord, then stop of work is only during the GRAP when it is operating. So I understand, my lord, the work which has been stopped by them is pursuant to, my lord, the action taken by the authorities on my complaint.
Yes.
Because the GRAP has a periodical, my lord, duration as such, my lord. So, my lord, I understand that once the stop notice has been given to them, that means that not de-host GRAP or no GRAP till the time, my lord, they hear the parties and decide the matter, my lord.
So your work stop notice is only qua GRAP 3 or is it to stop unauthorized construction?
Grab 3, my lord.
So when the GRAP 3 gets lifted, the work stop notice will will cease to have effect, right?
My lord, as of now, my lord, we have seen there is no unauthorized construction, but we'll inspect this property
There is no
today or tomorrow.
unauthorized
my lord.
construction according
No,
to you.
that was a case of the renovation, but we'll inspect today or tomorrow, my lord, this property.
They have not inspected the property till date, my lord.
So please.
We'll do it today or tomorrow, my lord. We'll file a status report also, my lord. Since it was a grab in operation, so that was the reason, my lord.
So on 24th December, this section 337 notice recorded what?
My lord, section 337 read with section 15 of NGT case, my lord, 10,000 cost was imposed on them on 24th.
That was
of
because he
December.
was violating GRAP.
Yes, my lord. And thereafter, my lord, on 27th.
But what
of December,
about the issue of whether they are issuing, whether they are carrying out any unauthorized construction? As per your instructions, they are not carrying out any unauthorized construction.
my lord, as per my instruction, we will inspect the premises by today or tomorrow. We'll come back to this honorable court by filing a status report, my lord. Since it was a case of renovation, as per our understanding, my lord, it was no new construction.
So I need to know because I'm going to make it a part of the order. As per your officer's last inspection, is this a
Yes,
case of
ma'am.
unauthorized construction or not?
It was a case of the renovation, my lord.
So it's not a case of unauthorized construction.
My lord, we have to inspect the premises, then I'll come back.
All right. So you'll inspect the premises and file a status report. In
Yes,
the
ma'am, we'll do
meantime,
it.
you will also grant a personal hearing to the parties on
Indeed.
on 1st January.
Indeed.
At what time will you give it? At 11:30 a.m.
11, that will be fine.
Who will be the officer who will give
My
it?
lord,
What will
A is the person, my lord.
AE is the concerned person?
Please, my lord. AE, Mr. Amarjit will be there.
We'll do that. And he'll list it before the roster bench, sir.
My lord, the petitioners are out of town, my lord. Lord, she may just have it on after 4th any day.
We'll have it on 5th of January, sir, then?
Please, my lord, please.
5th of January, a
Fifth.
working day? Yes, it is.
5th is Sunday. Sunday. My lord, 5th is Sunday, my lord.
6th would be fine, my lord.
6th is holiday, my lord.
Public holidays.
That's
Seven.
right.
Okay, 7th of January, sir, then we'll have it before the roster bench after that.
And my lord, in the meantime, status quo to be maintained.
We can't do, you are not available, they are willing to give a hearing. So anyways, there is a work stop notice given. They are saying that they don't find any unauthorized construction. I'll record the facts, but there's no need to issue a stop of construction right now.
So, my lord, one clarification I'll seek on behalf of police. If they carry on any renovation work, should we permit them or no? That is the question.
If lordship can't see the way
Please appear before the NCD on 3rd through your counsel. You please appear through your counsel, sir. We'll have it on 1st January. I'm sure till 1st January, nobody's going to start work. We'll have it on 1st January.
First January. It's all right.
Say, this is, Madam, this say issue notice. Mr. So-and-so enters appearance on behalf of respondent number 1 NCD and states that on 24 December 2024, a notice under section 337 of the NCD Act has been issued to respondent numbers 3 and 4. It states on 27 December 2024, a work stop notice has also been issued to respondent number 3 and 4 in view of the prevailing GRAP 3 restrictions.
Please, ma'am.
He states that after the service of this petition, a site inspection was carried out by the concerned officer on 29th December 2024, and the officer has instructed the council to state that no construction,
Construction is going on, my lord.
Sorry?
No construction as of is going on, my lord.
No construction or no renovation?
My lord, no renovation, sorry.
No
Because of the
renovation
work
work
stop.
is going on at the site. He states that he has been instructed to state that the nature of work being carried out at this site falls within the parameters of renovation and not construction. He, however, states that a status report under the signatures of the concerned AE will be filed before the next date of hearing. He states that the respondent number 1 will also carry out a fresh inspection and grant a hearing to petitioner and respondent numbers 3 and 4 on 2nd January.
Second,
On 2nd January 2025 at 11:30 a.m. to examine the rival contentions of the parties with respect to the nature of construction being carried out. And the decision of the AE will be enclosed along with the status report. Full stop. Learned counsel for respondent number 2 states on instructions from
illegal construction and the construction of building.
That is my case, my lord. This is precise.
We have followed it, madam.
what is you should give the name of the person who's here on states on instructions of so and so that SHO that the SHO upon receiving a complaint from the
Malas.
petitioner herein has forwarded the said complaint to respondent number 1 on 26th December 2024. Sir, then you please, the hearing that you're having on 2nd January is for the purpose of adjudicating on this complaint.
Yes, madam.
Very well.
we'll do it. We'll do it.
Lordship miss.
The hearing on 2nd January 2025 shall be for the purpose of adjudicating on the complaint of the petitioner's hearing. The MCD may also direct respondent numbers 3 and 4 to file their response before the MCD on or before 1st January 2025. Extra. Issue notice to respondent numbers 3 and 4 to all notes. Extra. This before the roster bench on in January, sir. End of January. Yeah, 3rd week of January.
My lord, till the time the adjudication takes place, my lord, there may not be any work. Yes.
On an earlier date, because somebody's property. That's why we're getting you an adjudication also on 2nd January. We'll have it on Rio.
Very well. And my lord, so far as petitioners are concerned, they may appear through counsel, my lord, on second lordship, since they are away. Lordship may just
This right. Petitioners are at liberty to appear to counsel before AEMCD on 2nd January 2025. And so he is making a statement that no work is going on.
Yes,
right?
madam. He's given this.
He's
He has
also
given his
filed.
appearance also.
Mr. Learned Counsel for Respondent number 2 states that similarly, police officials had carried out an inspection on 29 December 2024, and they found that there is no renovation work being carried out at the site. Okay. All right.
But can we have it on 7th, not in that case?
But, sir, you'll be able to give us a report by 7th, and your
My lord, we'll do it, my lord.
we'll make it 8th so that they can do filing.
My lord.
Is 8th okay, Mr. Ali?
8th is fine.
My lord, that complaint is taken on record, my lord.
So you just give a photocopy.
Lord, just one just
Here, my lord. I have a copy.
All right.
just one clarification, Lord.
Some original, Mr. Some original, give a photocopy.
I'll give.
Just for my understanding, Lord, the AE, Lord, I understand that the AE will adjudicate, Lord, or will any senior officer?
Adjudicate on your complaint which you have sent to the police station, which has been forwarded to them.
Very well.
Adjudicate on that, and he'll decide.
Which we have also given to anything.
Anyway, but right now I have this before me, so I'm just ready.
It's there. 8th of January.
8th of January. Highly
Please.
obliged.
Right.
Item number 10.
My lord, the petitioner here is only seeking protection till opening of the courts. So the notice was served on.
Counsel for MCD.
My lord, I am appearing, my lord, online.
Yes, Mr. Datta, are you planning to do anything before the vacation?
My lords may not say anything, my lords. I'll ask them not to stay away, my lords, till 7th.
But I have to record that you're not intending in view of GRAP 3, you're not intending.
My lords, grab restrictions are now over, my lords.
Okay.
So, my lords, my
Then
lords,
I just record that you're not intending to take any steps before 7th January 2025.
please,
right?
my lord, please.
I'll record that and I'll dispose of you. Please avail
Please.
of it. Just take down writ petition civil 18030. This is a petition. Madam, this will be writ petition and CM application 76667 of PwD. This is a writ petition seeking a direction to respondent entity to maintain status quo and not take any demolition action qua the flat of the petitioner till 10th January 2025, so as to enable the petitioner to file an appeal before the appellate tribunal NCD. When a counsel for the petitioner states that due to the intervening court vacation, the appellate tribunal NCD will start functioning from 3rd January 2026. Have you filed your appeal already?
No, my lords. The notice.
Filed it before 3rd January?
Yes, my lord.
He states that the appellant undertakes to file the appeal before 3rd January 2026. Mr. Kapil Datta, Lawrence Standing Counsel for the MCD, states that the MCD does not intend to take any action, any demolition action in
Pursuant to
pursuant
demolition
the
order dated-
impugned order dated 10 January 2025 until 7th January.
My lords, it is, my lords, 18th of December 2024, my lords. Demolition order is, my lords.
18 does not intend to take any demolition action in pursuant to the impugned order dated 18 December 2024 until 7th January 2025. So I'll make it 8 January, okay? Until 8
Fair enough.
January 2025. Full stop. The statement of the Learned Standing Counsel for NCD is taken on record in view of, and he bound down to the same. In view of the above, the petition is disposed of, issuing a direction to the petitioner to ensure the filing and listing of its appeal on or before 7th January 2025.
Much obliged.
So the petition stands disposed of.
Deeply obliged.
Please.
Item number 11.
For 11, the urgency is that the re-examinations will take place in the first week of January.
Is it taking place, sir, the re-exam?
Lordship, the institute does not officially announce the re-major exams date because the
When is it likely to be done?
Lordship in the first week of next semester, that is.
So no, is it after 7 January or before 7 January?
That has not been decided yet because the re-major exams are only for those students who secure I grade or E grade in their major examination. As far as the petitioner in this case is concerned, her admission was terminated from both the courses in the month of September, and the major examinations were conducted in the month of November.
So
Then it is
re-examination is for people who secure high grade or
or
E grade
in their major examination, ma'am. Your Lordship. It is-
and she has not, because she did not write the exam, she has not
Therefore, she is
secured
not
it, so
eligible.
she's not eligible.
it is-
Sagarwal, let it come up before.
My lords, I am not eligible. My lords, today they say I am not eligible, but I was prevented from taking these exams because of my wrongful termination. Would my lord have the academic?
Mr. Agarwal, there's a lot to be said about clause 11. You have not challenged it. There was a declaration.
My lords, even assuming clause 11 applies, I have to resign from one. They have removed me from both. They ought to at least allow me to continue in one.
So when you decide this matter has to be deferred finally. There's
Well,
nothing, and right now the
exams-
dates are also not out.
My lords, the exams will take place. May I just show you one paragraph?
Eligible if you have not, it is only for people who have received high grade and E grade in the major exams, then they can sit for.
But if I can, my lords, prima facie show the court that my cancellation was wrongful, then the question of eligibility goes.
Take up the matter finally and dispose it of. Then we'll prepone the date of hearing, we'll hear it finally and.
My lords, it's otherwise listed on the 7th.
Then let it be on 7th, otherwise I am not inclined, I've seen your clause 11,
Grateful.
both of it. So you please either
Great.
take instruction, we take up the whole matter and dispose it of, otherwise you take your chance before the date.
Great. We'll take our chances before the
Learned counsel for the respondent states that the date sheet for the re-examination. This is in CM application, okay? CM application 76249 of 2024. Learned counsel for the respondent states that the date sheet for the re-examination has not been issued till date. And he states even otherwise, the petitioner is not eligible to write in the re-examinations in view of the fact that only the students who had secured high grade or E grade in the major exams are eligible. He states it's a matter of record that the petitioner hearing has not written the major exams which were held in
The month of November.
in November 2024. The counsel for the applicant petitioner requests that the matter be listed before the roster bench on date already fixed.
My lords, may only observe since there is no date, no announcement date, the matter can be.
That fact, I'm just
Yes.
so
There's one more aspect, my lady. The last date to pay the fees is 31st December. I'd be at least.
to give you permission to get admission, that's
Great.
the least of your problem.
Great.
That will be done.
Obligations. Item number 12.
Your Ladyship, this writ petition challenging one of the key answers to question number 18 of shift 2 of CAT 24 examination. The reply to the said petition was asked on 23rd of December itself.
24th when the matter was.
24th, yeah.
This was issued.
24th of last date. I suppose they have filed the reply because we have received the soft copy. So
What's your reply, sir?
Lord, we filed it last night.
What's your reply?
Our reply is that it's a subjective question. There is a committee of experts which has examined it. And your lordships know, my lord, there are so many judgments which say my friend has to show something really erroneous in the answer. I can show the answer. I have also got in sealed cover the credentials of the committee and the analysis of the answer. I can pass it on to your lordship. Not if your lordship feels that the analysis is not correct.
When is the admission beginning?
Process is on.
What is his ranking?
We don't know yet. That only the candidate knows. The result came out on 19th of December, 24.
So what's your rank in that, your results?
my percentile is given, Your Ladyship. There is a history. In CAT 23 also I appeared. My percentile was 98.13, wherein I was offered admission from 2 of the IIMs. But I took a risk so as to improve. Now, this time, this particular question makes a difference of at least 4 marks on the face.
Right now, how much is it in the absence of this question? How much have you scored?
Yes, Your Honor. .52. The
And if
present
this question
percent,
is considered, then how much will you score?
that would definitely go above 99 point something. Because I have taken a risk, Your Honor, I am a serious candidate. And this makes a difference of 4 marks. And resultantly, Your Honor,
You want to consider the reply and file your rejoinder, we'll have it on 3rd January then.
yes, Your Honor, if it is on 3rd January, we'll file our rejoinder also because there are certain other discrepancies also.
This question we have to.
No, not question, but otherwise, as they say that they are the experts, they don't commit mistakes. Human error is, yeah, that cannot be.
This question.
So on 3rd, yes, we'll file the rejoinder.
I may only make a request. The process is not going to get over anytime soon. Would your ladyship consider having it on the 7th, the first day of reopening?
Okay, fine.
Your Honor,
But what do you mean the process? Because his right that he is challenged over here can't be prejudiced. So you tell me what is the,
He can press his challenge on the 7th also. This process is not going to conclude by the 7th.
which is the process where his rights will get crystallized as far as your process is concerned, which is that stage at which it will become irreversible. So when you start considering admissions.
I'll just.
Yes.
Your Honor, may I submit?
So just a minute, let me at least understand when do they start considering
Please.
admissions? That's the
They
date.
already
when-
started sharing the
End of
marks.
January is when the interview process starts. That's when it sort of becomes irreversible. So 7th or 8th, not if your lordship would have it. I'm only saying that.
Just crystallize your statement so that I can record it, so that his rights are not prejudiced. If this petition was allowed in his favor, and which is that stage where his petition needs to be determined before that stage.
But then in that case, let it be on the 3rd. There's no difficulty.
Yes, Your Honor, because they start sharing these marks with the Institute 96, other Institute 24 IAMs. So they start sharing these
You
marks.
start sharing these marks with the other institute.
We've already.
They may not,
Then let it be 3rd.
Let it be 3rd, no difficulty.
Senate Council.
you know, till that time, they may not operate on that result.
We are having on 3rd
3rd
January.
is only 2 days.
We are having on.
All right.
Senate Council for respondent number 2 states that he has served a copy of the reply on the petitioner.
And it's been filed
It
last
with the
night.
registry and filed it with the registry. The respondent is directed to have the reply brought on record. If not, Senate Council for the petitioner seeks 2 days' time.
Please, Your Honor. We'll file the rejoinder.
Seeks time to file rejoinder. He is directed to serve an advance copy on the respondent and file the same on or before 2nd January.
Please, Your
2025. List before the vacation bench on 3rd January 2025.
Item number 13.
All right.
Look, they are all PwD category candidates, my lord. And now the latest development is that, my lord, government has deferred the 3rd round of counseling. Earlier, it was supposed to commencing from 26th December, but on 24th December, they have deferred the counseling, 3rd round of counseling for detail is not available. And they were supposed to file affidavit, my lord.
Okay, just call out Postmaster, item number 13.
Item number 13.
Who is the counsel for the respondent?
Mr. Ajay, we have served.
Okay, I'll pass it over, just call him again.
No.
I have one matter. I'll just 1 or 2 matters, you just come back.
Passed over item number 5.
Yes, counsel.
Let's say we'll make the payment by tomorrow.
Or what time, sir?
During the bank hour by 4.
So by 4 p.m.
By 4 p.m. no problem.
It
And let's say 1
50
point,
lakh,
we have made the payment of 50 lakh after the filing of this application.
Yes.
Whatever payment you've made, nobody can deny you that
Yes.
payment.
We
That
are
is
just-
correct. You will complete the payment, which was due in December 2024, up to December 2024 by 4 p.m. tomorrow, right? Okay. CM application 7664 of 2024. This is an application seeking extension of time to make the payment, to make payment of the installments which have fallen due on 26 November 2024 and 26 December 2024, as undertaken with a order dated 29 July 2024
and 25th November also. 25th November.
That was modified.
Page 16.
The counsel for the applicant petitioner states that after filing of this application, a part payment of rupees 50 lakhs has been paid. Full stop. He states on instructions that the balance amount of 1.350 crores
Payable up to 26 December.
payable up to 26 December 2024 will be paid at 4 p.m. on or before, will be paid on or before 4 p.m. 31st December.
My lord.
He undertakes that no further extension will be sought. Current counsel for the respondent states that to this limited extent, the respondent has no objection. Otherwise, the respondent is upholding the period sought in this application.
And we'll have liberty, my lord. Because there are
This court
page 15, page
not inclined to extend, was not inclined to grant the relief sought in this application in view of the categorical directions passed by the predecessor bench on 29 July 2024 and 25th November 2024. Full stop. However, at the request of the petitioner by way of last extension, the time period has been extended until 4 p.m. at 31st December 2024. It is clarified that if the said payment is not made as undertaken before this court today, the petitioner will be at liberty to initiate process as reserved with the order dated 29 July 2024, including approaching NCDRC for issuing of the non-bailable warrant. With the aforesaid directions, application stands disposed.
I'm so grateful. Sorry, my lord. As regards the undertaking given today to my lord, that my liberty also. Suppose they don't give, I will take. But as regards the contempt is concerned, giving undertaking before my lord.
The non-bailable warrant is the biggest thing.
I'm leaving.
Order of the court is not, it is not the order of the court. It is the warrant.
That is in the hands of police, and that it directly I come before my lord, they will give it.
Undertaking I have recorded.
No, I'm so grateful. I'm so grateful.
Obliging.
Original side matter item number 1.
एक पास हो रहा है 13 केस original side item 1. Mr. Dogra, are you in original side item 1? 14
is there.
Item 14 is issued. What is the number of your matter?
CS commercial 1217 of 2024.
Is this your matter?
Please, minutes.
Yes. So you are appearing, Mr. Dogra, you are appearing for which defendant?
Lots 2 and 3, I'm appearing for, and Milots, I have a preliminary objection. If my lady wishes to hear them, Milots, then I'll hold my Milots thoughts till then. Otherwise, Milots, is a serious issue of jurisdiction, Milots. In this matter, nothing has happened within the jurisdiction of my Lord's Court. All the disputes are in relation to Sector 127 Noida. It's a dispute between unit owners and the builder there and the maintenance committee, the maintenance company. Defendant number 2, registered office, corporate office in Noida. Defendant number 3, registered office, corporate office, Noida.
Registered office.
Please, Milots. In fact, I'll show from the plaint, because there is a wrong statement been made that the registered office is in Delhi. That's 2.
Independent, okay.
Thirdly, the rights that they have is under a builder-buyer agreement, where there is a specific jurisdiction clause of courts in Noida, Gautam Buddha Nagar, as well as an arbitration clause. In addition to that, there is a sublease, a tripartite agreement, where there is exclusion of jurisdiction of all courts other than Milord's Gautam Budh Nagar. Defendant number 1, who Milord's is my vendor, has been made a party saying that because he is uploading some content from Delhi, so therefore this court has jurisdiction. Defendant number 1, Milord's, they have no privity of contract with defendant number 1. He's a service provider, my vendor.
All right, I understand this. I just have one question, sir. These are all your unit holders. I understand. We'll preserve all your jurisdictional issues. Today, do you have any understanding with them on your CAM charges? Do you have any written understanding with them on a CAM charges?
My lady, just have for a moment, the builder-buyer agreement for a moment.
So what is the amount that has been agreed? That is a clause. Have you, after when you were entering into that tripartite agreement with them, did you enter into any agreement with them on CAM charges?
No, my lords, there isn't an agreement till date which has been executed, but the builder-buyer agreement says that they will pay the CAM charges. So
Builder-buyer agreement is between defendant number 3 and the plaintiff.
Please, my lords.
And tripartite agreement is
between Noida Authority, defendant number 2, and the plaintiff.
And right now, the action which is impugned is of which defendant is really concerned with the CAM charges and the electricity charges?
That would be defendant number 3.
Defendant number 3.
Please, my lords.
So the real fight is between defendant number 3 and the plaintiff.
Please, my lords. And
okay, now just tell me one thing. I noticed that in the memo parties, I think there are a lot of lawyers. Now just tell me one thing. At the end of the day, they have to pay CAM and they have to pay electricity. There's no doubt about it. But also as a customer, they are entitled to some transparency on the charges being, charged and being recovered. There appears to be just a breakdown of communication. Anyways, this is a CS-com suit. Mediation should have been explored. And now that you have stepped into the matter, why can't parties just sit down and have a meaningful understanding? I am keeping all your objections on territorial jurisdiction open, only for the purpose that can parties arrive at a mutual understanding of CAM. You want to collect CAM, they have to pay CAM. But today you are not being able to collect CAM and they are not paying CAM. Both is happening. So why can't you even in fact use this opportunity to enter into an agreement with them?
Can I just say this?
Yes.
Amongst all the unit holders there are at least 21 who haven't. And Milords, it's not as if all of them haven't paid CAM charges. Some of them have. 4 of them, in fact, have paid. The defaulters are the separate ones. So 4 have paid, 16 haven't paid, or 17 haven't paid.
They will pay it.
So
what if 4 have paid, the rest of the 16 will pay it as a goodwill gesture.
Let them pay.
Yes.
Milords, if they pay, Milords, we can talk, but there can't be an injunction for me, Milords.
It's okay. It's all right, Mr. Dogra. Please understand what I'm telling you. I am not saying anybody should consume electricity or use a property without CAM charge. But today an opportunity has arisen. You can do that. You can use this circumstance to, in fact, enter into your agreements with these 20 people. They certainly can't have a stand that I will not pay as much as my other unit holders are paying. So whatever other unit holders are paying, they will pay. But you have to use this opportunity to settle the matter with them. I'll keep your objection of territorial jurisdiction open. But at least use this opportunity to settle the issue, no? You can't be at war with your unit holder.
That's, if I may again, if 95% of our unit holders are not at war with me, and if it's only 5% who want to, in terms of area space.
Fine.
But
Mr. Chadha.
May I first straight away will not take your lordship to the
Sir, how
objection.
many units do this building have?
I'll just.
You are 20, but otherwise, how many units does this building have?
Well, they don't have exact numbers because they, despite the.
The approximate number, sir.
कितने हैं unit holders? Approximately, do you know? Or you don't know? But they don't have any instructions in that.
May I just say
around 40 units.
And how many floors?
In each one tower, there are 5 floors approved, but they have illegally.
That is not my concern.
Yes.
Your other concerns of unauthorized construction is not a subject matter. So please tell me it's 40 units into 5 floors in one tower.
Yes, Lord.
So how many towers?
There are 4 towers.
Okay, so we have 4 towers.
Subject to correction by my learned friend, my lord, because they know.
Right, I just want to understand your case. So there are about 800 units. In 800 units, the rest of, let's go by what they are saying, that 90% people have signed their maintenance agreements, okay?
So there are unsold units also in these towers, my lord.
Yes. Now tell me how much CAM charges have you been paying?
That's
How
the
much?
question, my lord, which I have,
Have
my
you
lord,
been paying or not paying?
Are you paying anything? No, my lord.
You are not paying any CAM charges. How can you not pay any CAM charges if you're using a
Except
building?
being it was one, my lord, never raised on us. Second, my lord, there is no breakup, my lord, that CAM charge. What is
That
the
breakup we'll do later, sir, but
Very
you
well.
will be using your premises without paying CAM charges, no? Especially if you're coming to court, you will have to pay CAM charges.
property still is under renovation, my lord. There are still under, my lord, construction going on, my lord.
Are all these plaintiffs in use and occupation?
They are in use.
So then the party is in use and occupation. I can
We are not shying away, my lord. We'll pay that. But I bow down to what is falling from your lordship, my lord.
Okay.
We are ready to pay that, my lord. But
Yes.
please see the manner in which, my lord, it is being asked to us. And what my learned senior colleague, my lord, just mentioned that, please have, my lord, page 48 of annex, my lord, index 4. That's the builder buyer agreement. And what does it say, my lord? And your lordship have directly, my lord, asked that question to them. Is there any agreement between them, my lord, before asking for CAM charges? There is none, my lord. Please have that agreement for a merit, my lord.
Okay, so there is none. You've not entered into a maintenance agreement.
There is nothing, my lord.
Okay, but now, Mr. Jindal, we'll have to be practical.
Please,
There is no maintenance agreement, but you are occupying a property and the property is being maintained.
Correct, my lord.
So we can't say because I have not signed an agreement, I will not pay CAM charges.
No, my lord. My instructions are, we are ready to pay that, my lord.
Yes.
May please, my lord, even
So
record
have
that.
you
My
have you been
instructions
notified about the CAM charges?
are- No, my lord.
Have you have not received any monthly bill for CAM charges?
Received anything? Ah, yes. My lord, that's what the problem is, my lord. They are, my lord, asking for something which is neither, my lord, in black and white, my lord, not written. And what are the services they are providing? What are the?
You will have to crystallize your submission. I will not be able to adjudicate on a vague submission.
Please, lord.
You'll have to tell me if you have been receiving a monthly notice of your CAM charges.
Yes, my lord, we have been receiving, my lord.
Yes.
We have receiving that, my lord.
Yes. So then why are you not paying it?
My lord, because reason being, my lord, those invoices which has been raised to us, my lord. Lord, one, there is no breakup that what is the common area maintenance charge they are asking us from, Lord. Second, my lord, those are all vague, my lord. On what basis have they been charging us, my lord, is not clear. Henceforth, my lord, this dispute has arisen, my lord, and we are before your lordship today, my lord. Had that been clear, my lord, if in case, my lord, they specify that we are charging X amount to you, my lord, for these for this common area maintenance, my lord, they'll pay that. And today, my lord, what are they doing, my lord? With these prepaid electricity connections, my lord, now being installed in the tower, my lord, they are clubbing these CAM charges in the absence of any agreement, my lord. And though, my lord, with the threat that your electricity will be disconnected if you don't, my lord, accede to our requests.
Okay, and how are you paying the electricity bills?
My lord, as per the actual consumption, my lord. Whatever bill was being raised, we were paying.
That bill is being raised on you separately.
Yes, my lord.
Maintenance bill and the electricity bills are being raised on you separately.
Yes, my lord. But today they wish to club that, my lord.
That's okay. And the electricity bill you have paid up to date, but
Yes, my lord.
CAM is outstanding in its entirety.
Correct, my lord.
That may not be correct. There are at least, I have the list before me, sir. There are 1, 2, 3, 4, 5, 6 plaintiffs who have claimed. There's 0 outstanding against their names.
1, 2, 3.
No, Milords, I'll just name a plaintiff number 2, plaintiff number 3 and 4, plaintiff number 8, plaintiff number 10, plaintiff number 12, and plaintiff number 21. There is 0 or negative outstanding against these. Against the other Milords, there are outstanding CAM charges.
Is CAM charges or electricity charges? CAM charges. Agreement between them.
Okay, so Mr. Shraddha, what is your answer to the territorial jurisdiction objection?
Please, Lord. Lord, may please see, my lord, defendant number 1. It's a bilateral agreement between 1 and 2. That 1, my lord, will be providing all these prepaid meters, electricity connections and everything, my lord.
Yes.
He is based in Delhi and their own email says so, my lord. Please have that email for a minute, my lord. Please have page 80.
Okay, so D1, what about D2 and D3?
Lord, D2 and D3 are, my lord. D3, my lord, is the one from whom these properties were, my lord,
Yes.
they purchased. Agreement to sell and sale deeds were, my lord, executed by them, my lord. They were based in Delhi. My instructions today are, my lord, henceforth they have said so, my lord, in their memo parties also, that their offices, they may have shifted now, my lord, for what good reasons. But as on the date, my lord, when these executions were done,
As on the date of filing of the suit, where were they?
my lord, their addresses finds mention as Preet Vihar East Delhi, my lord,
That's in your memo of parties.
as per the lease, my lord. And we have said so also at 7th floor, Bhutani, so and so, my lord, Gautam Budh Nagar.
Okay. And what is your answer to the exclusive jurisdiction clause?
My lord, reason being what I am today before your lordship is in respect to a very, my lord, municipal issue. That is, they may not club, my lord, the electricity meters, prepaid meters and CAM charges together. Reason being, my lord, the electricity and all, my lord, these services, there is a cloud server which is being managed and operated by D1. He is based in Delhi. So, my lord, in case if any, for example, I'll just give an example for Airtel, a service provider, he may be based in Mumbai, but he has, my lord, offices and, my lord, connections in Delhi also. They are operating from Mumbai. Similarly, my lord, this gentleman D1, my lord, which is an agency, he is based in Delhi, my lord. He is in the process of disconnecting or, my lord, giving electricity. In case if there has to be a disconnection, my lord, it will be done by D1 only. And he is based in Delhi. The cloud server, everything is based in Delhi. Henceforth, my lord, and their own email says that entire services in respect to these electricity and CAM charges will be provided by D1. Henceforth, my lord, I have jurisdiction before your lordship. Their own email says so, my lord, which has been sent to us, requesting for, my lord, these CAM charges and electricity to be clubbed from January 1, 2025.
Okay. And so the electricity meters have to be installed from 1st January.
Prepaid electricity meters.
An objection that CAM charges can be collected through that, the meters can be installed.
And we are ready to pay that also, my lord. We are not shying away. We'll pay those CAM charges also. Your lordship is correct, my lord, since we are using that premises, my lord.
Yes.
We are bound, my lord, to pay that.
Yes.
But there has to be a systematic, my lord, approach. There has to be a breakup, my lord, that you are charging CAM charges for.
You have to articulate the argument. So you are willing to pay CAM charges. You're willing to pay your
My instructions are yes, my lord.
Yes. So now what is the concern you have? Please articulate.
That they may not
so that
club CAM charges with electricity meter, my lord, these prepaid meters. That's the first concern, my lord.
now, if there is a system where there is no dispute on the CAM charges and then there is no dispute on the electricity charges, then what is the harm if it is getting collected through that meter
Yeah,
system?
sorry, make
No, my lord, then there has to be some agreement, my lord. This is
Make
what
a-
their
to
builder
resolve
by
the-
agreement says.
Yes.
My friend is here. Milords, if they are willing to pay the CAM charges and they are not objecting to installation of the meters, my lady may refer us to mediation. We'll
I'm so grateful. This was, my lord,
But Milords, they'll have to pay the CAM charges before it goes to mediation? No, can't be, sir. The answer, you already agreed to pay. And secondly, Milords, there will not be any opposition to, Milords, we'll resolve it. But Milords, there are 95% other unit holders who are agreeable to, Milords, paying as per the, Milords, as per the meter. And Milords, this is not something which is novel or new. This is now the norm. That CAM charges and electricity is, Milords, collectively collected based on a meter reading, and there is prepayment of that. But in any event, Milords, despite my, Milords, I will say strenuous objection to territorial jurisdiction, because it's fallen from my lady, we will, Milords, try and resolve.
Lord, when I say that I'm ready to pay CAM charges, my lord, I mean to say, my lord. I'll just clarify that aspect also, my lord. Let them come fair to it, my lord. They have charged today, my lord, on what basis, my lord, I don't know. They have been charging CAM charges for what reasons and on what basis, my lord, we don't know. So that all, my lord, can be discussed in the mediation, and my lord, once for all, my lord,
That's okay. That's fine, Mr. Chadda. The only thing is, in principle, nobody can use a unit in
Correct.
such a big place without paying the CAM charges. So you please pay the CAM charges without prejudice to your rights and contentions. And we reserve the right to adjudicate upon the claims, okay? They will give you a breakup also of the services that are included in it. That's your concern?
But that's our
You know
concern.
which
Yes.
is the services included?
Correct.
I'll issue a direction. You will deposit the CAM charges and they will give you a list of each service which is included in the CAM charge.
That's fine.
And expenses.
25% of what?
25% of entry only. Shape the mediation.
No, their concern is, my lord, that as of now, my lord, they will pay that, my lord, but let's, my lord, have that percentage, my lord, to be deposited, 25% out of that, my lord, total amount what they have raised as of now. They'll pay, my lord, these demands are unreasonable and henceforth we dispute them and we are before your lordship.
How much fees per month are they asking you?
8. I said no.
Milords, they are charging 18.5 rupees plus GST, which total comes out around 21.83 rupees per square feet. However, Milords,
So we just take it 18.5 because GST is the not a money.
Milords, I'm just giving you the exact figure, Milords. I'm just giving you the exact figure.
Plus 18%. Okay, so
Please, Milords.
how much does this 18.5 come to per unit?
Milords,
These are standard size units or they are all
no,
various?
because there are various sizes and as per the per
Now,
square feet they are charged.
18.5 that they are charging.
Please.
What is your objection to rupees 18.5?
Milords, as per our calculation, even I am one of the plaintiff in that suit, Milords,
Yes,
and I'm the unit holder. And what is our calculation? They are hardly incurring the expense around 4 to 5 rupees per square feet. I have a data, Milords, I will show it.
That's okay, but do you really think this court is going to analyze that data and not let you pay till? And even if I am
Milords, what we are submitting?
Analyze your data with you. We'll sit down and we'll analyze the data with you. But today, can
Milords, we have sent the email. We have sent the email on 1st of October as well to kindly provide this. Milords, may kindly refer to
We have
this
been
annexure.
asking them, my lord, that please provide us. That
Please
email.
provide us, but they are desperate about like
They're
not
silent
furnishing
to
this.
that, my lord.
They are
They're
silent.
not answered
They are not
anything.
keen on submitting all these things, Milords.
you have to deposit it, the CAM charge.
Milords, we are ready. Milords, we are ready.
Deposit it, they will give you the details and the
Obviously.
matter will remain sub judice. We will adjudicate on it. You can't
Milords,
do this.
Lord, we say, my lord, we'll pay 50%.
50%, my lords, until-
to us, my lord. Rest, my lord, once we.
Once the
come before
mediation
the
will
lordship,
over,
we have to
whatever
pay.
the statistics comes out, Milords, we are ready to pay. But Milords, as an interim relief,
Mr. Chadda, please. You are a unit holder.
Correct.
You are occupying the unit.
Very well.
A bill has been raised on you. When was the first bill raised at 18 rupees 50 paisa?
since day,
From day one. What was that? 2000?
as per the positions of the different unit, January 23.
23 January, they had taken possession, my lord.
We can't hold court process. Court is not going to be a part of this. I will reserve your right that whichever that email is where you have sought that without prejudice to your right to seek accounts,
Correct.
you are depositing this money to show your bona fide. We can't use the court process to not pay our CAM charges.
Correct,
You
ma'am.
will pay it. If we find you are entitled to an adjustment, they will. I'll record this that in case the court holds that 18.50 paisa was too much, fine, we'll give you your refund. But you cannot withhold monies like this. That's not the object.
So we'll get the refund.
That's,
So in that, my lord, if the lordship allows, because there are other stakeholders also, my lord, we'll take instructions on that, my lord. and we'll
Yes,
just-
you please take instructions. We will reserve your right
Very well.
to verify the claim that they are making and then satisfy yourself that the amount sought is reasonable.
I'm sorry, may I just say one?
Yes.
But if it is going to be adjudicated, then Milords, it will be difficult for Milords us to give concessions to. Because the idea was, let them pay, we will go to mediation, we will resolve it. If this honorable court wishes to get into Milords the details of whether the payments are proper or not, then Milords, perhaps the issue of jurisdiction might need to be decided before. So therefore, Milords, to avoid Milords any acrimony between the parties, my suggestion was, let them pay, we'll go to mediation, we'll resolve it there. But Milords, the moment my lady wishes to, or this court, Milord does get into the actual calculations, then Milords
Then I'll let them only pay 50% right now. I will not observe all this. I'll let them pay 50%. I'll not make this observation.
May I just say this? I've been paying GST on the entire amount.
But then you also have to do one thing, no, Mr. Dogra, please understand. You also as a builder have to ensure he signs the maintenance agreement with you, and you also have to answer him that why you're charging 18 rupees 50 paisa. See, you are also recovering money without an agreement. So right now, please, either we don't make that observation, they deposit 50% and you go to mediation.
It is not as if we've not asked them to sign it. There are other unit holders who have signed
See,
it.
Mr. Dogra, I understand. So please, either they pay 50%, I don't make that observation, or they pay 100% and I make that observation. Because we have to protect their claims also. They are not saying that we agree, but you are saying, yes, I'll satisfy them in the mediation that I have a reasonable basis for charging 18 rupees 50 paisa. Surely a customer is entitled to know why he's paying 1850. This is not a retail selling that take it or leave it. It's a maintenance agreement. It is not a builder-buyer agreement.
That's exactly what I'm saying. In the builder-buyer agreement, sorry, I'm taking a bit more. Builder-buyer agreement, there is an obligation on them to pay. There is also an obligation to sign the document, which they refuse to sign, is my instructions. Other people have signed it. Today, the issue why they've come before what is not that the camp charges are whatever they are, because there is a proposal of installation of meters where you'd have to prepay the charges. That is the issue to be adjudicated. So therefore, my lords, again, respectfully, for any such dispute to be entered into, the plaintiffs will have to cross the hurdle of jurisdiction A.
So don't on vacation, I can only pass an interim order. I'll keep all the preliminary objections open and I'll take them up on the reopening.
There is one more issue. They had filed earlier suit before the commercial court, what is disclosed here is that it was withdrawn.
Yes, we have said so.
Yes, of course. Without
because of pecuniary jurisdiction, it was withdrawn, my lord.
May I just pass the copy? So, my lords, the matter got taken up there. And on for a page and a half, my lords, the court observes.
Yes.
If I may just read. This is a designated commercial court, jurisdiction up to 3 lakhs and 2 crores. In terms of section 6 and 12 of commercial court, plaintiffs are required to mention specified value of subject matter to enable this court to ascertain the jurisdiction to entertain the present case. However, in the entire claim, the plaintiff has not mentioned the specific value of the subject matter and value of the suit. In para 29, plaintiffs have mentioned requisite court fee of 1,000. Further, in para 30-31, they have mentioned assessment of 200. Therefore, this court has raised a query upon the council how this court has pecuniary jurisdiction. In reply, the plaintiffs submit they filed a number of documents which show the value of the subject matter. As mentioned above, the plaintiff is completely silent regarding the specified value of the subject matter and value of the suit for the purpose of
jurisdiction.
All I'm reading is the last paragraph. In view of the foregoing, the first question to be answered is whether this court, being the commercial court, has pecuniary jurisdiction to entertain the present suit. Hence, it is not empowered. It was, my lords, not empowered to grant the relief, and it was adjourned to 13th of January. Now, 2 hours later, there is a subsequent page order where they say we have instructions to withdraw. Now, when a relief is rejected, interim relief is rejected, the case gets withdrawn and then filed before my lady. And after that, Lord's concessions are sought. Lords, I'm sorry, but Lords, equity has
you don't have to give me concession.
Not to my lady, my lord. The concession is always Lords. Yes. So therefore, all I'm saying is, if my lady would just consider,
right,
Lords, let them deposit the charges.
Yes.
Will my lords resolve it in mediation? That is, my lords, something which my lady would consider directing us to.
Right. Yes, sir. Have you taken our instructions?
Lord, in respect to my lord paying that 50%, my lord, and in case if your lordship, my lord, records that if we are able to establish that, my lord, then that excess amount will be refunded to us, my lord. We will pay that 100% also. Because they want, my lord, they want settlement, they want, my lord, the entire amount to be deposited.
It fell from the court, and I agree.
Therefore, see, once you, before the mediation, you have to explore those possibilities. There are other issues also, my lord. So if you are willing to, my lord, explore all that, my lord, we are not shying away, my lord. I have instructions to say, we have been paying electricity charges, my lord, as per actual consumption. We are still paying that. That's up to date, my lord. Only question is, my lord, the camp charges. My lord, there has to be some agreement, my lord. The lordship have rightly said, my lord, there has to be something, my lord, in black and white, my lord, that we have to pay this 18 or 14 or 22, my lord. There has to be something on record. And you are raising, my lord, these invoices for X amount, my lord, on your own considerations. And there is a threat that from 1st January, if you don't pay this, my lord, electricity will be disconnected, which my lord, got disconnected on 4th December. There were certain units, my lord, whose electricity was disconnected.
I have no sympathy if you don't pay CAM charges.
No, my lord, we are paying, my lord,
My
lord, we have
That's
come to
okay.
what.
I don't believe as a court that court should be an instrument.
Correct, my lord. I will never, my lord, say that, my lord, that we will not pay that.
So I'll just pass an order, whatever seems appropriate.
Please, my lord.
IA number 4997 of 2024. Since defendant numbers 2 and defendant number 3 have been duly served and they have entered appearance, the relief sought in the application has become infructuous. Is anybody appearing for defendant number 1? You're appearing for defendant number 1? Just say defendant number 1, 2, and 3. Who's your lawyer? Okay. Right. Okay. All right, sir. All right. IA number 4996 of 2024. This is exemption of original documents. Just pass the standard order. Then you say that IA number 4995 of 2024. This is an application filed by the plaintiff under Section 12A of the Commercial Court Act, seeking exemption from exploring pre-institution mediation and settlement. Your senior counsel for the plaintiff states that since the interim reliefs sought in the suit will become infructuous as on 31st December 2024, the plaintiff has sought an exemption
வால்யூம் எதுவும் வரல. நீ கேட்டுட்டு தானே இருக்க, வந்துச்சுன்னா எனக்கு சொல்லு.
My lords, may allow me to mention.
Courtmaster, sir. Courtmaster, sir. Courtmaster, sir. Sir, Courtmaster, sir.
कोर्ट मास्टर सर वीसी पे आवाज नहीं आ रही है कोर्ट की।
Court Master, sir.
मास्टर सर
Sir. Courtmaster, sir.
Courtmaster sir. Courtmaster sir, kindly unmute the court, sir.
आप यहाँ से कीजिए वहाँ से कीजिए ऐसे नहीं कहीं चल रहा है कहीं कहीं अरे यार ठीक है मैं तो
Court Master, sir. Court Master, sir. Court Master, sir.
बोलिए मैडम जी।
Court Master, sir. Item 13 take up हो गया है क्या?
कौन सा 13?
Yes, sir.
पास ओवर है।
पास ओवर हो गया है?
पास ओवर है, यूनियन ऑफ इंडिया में से किसी को बुलाना है।
अच्छा ठीक है सर, मतलब अभी टेकअप होगा।
पहले प्रोनाउंसमेंट होगी, उसके बाद आइटम नंबर 13 ही चलेगा। ठीक है जी।
ठीक है सर, थैंक यू सो मच सर, थैंक यू। और
बता दूंगा भाई।
कोर्ट मास्टर सर, एक और रिक्वेस्ट है, बीच में कोर्ट म्यूट हो गया था, ऑडियो वीडियो सब ऑफ हो गया था, तो कैन यू प्लीज काइंडली इंश्योर कि ऑडियो वीडियो ऑन रहे सर।
ऑन है तभी बात हो रही है मैडम।
यस सर, मतलब थैंक यू सर, थैंक यू।
फ्रेश है भाई ये तो। आ गए इसमें, आता होगा इको, मेरे में तो आ रखे हैं। कौन सा केस नंबर क्या था कुछ? पार्टी नेम क्या है आपके? बट आए ये पता नहीं कौन सा। वो नहीं आया अभी, आ जाएंगे। अभी सर कुछ क्लियर नहीं है, क्लियर नहीं है सर कुछ। उसमें JRP डेट ओरिजिनल साइड का वन भी कर सकते हैं CS computer to 1217 अच्छा ये ओरिजिनल साइड पे आइटम नहीं है कोड फ्रेम दे दो 24
अच्छी तेरा कम्युनिटी सर तेरा
मुस्कान का मुस्कान का
जी सर जी सर सर किसी को भी सिंगल कैरी आप सर किसी को अन्य को भेज दीजिए मैं जी जी आप 50 ठीक जी 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 अगर तेरा नंबर क्या है दो मिनट रहते चलो हाँ चलो लिस्ट में क्या आया नंबर चेंज
किसी और को नहीं दी, किसी ने भी प्रोनाउंसमेंट के लिए कोई है क्या सर? हाँ जी। कौन से नंबर में करा?
सर 3 में मैं हूँ प्रोनाउंसमेंट में।
आइटम नंबर 2 में
सर
आइटम 4 में मैं हूँ।
ठीक है सर, ठीक है, बस करवाते प्रोनाउंसमेंट।
में भी प्रोनाउंसमेंट के लिए है।
कौन सा नंबर मैडम? पार्टी नेम क्या है?
MALLP मुकुल एजेंसीज LLP वर्सेस समनलाल शेर सिंह।
अच्छा, आप गोयल मैडम बोल रहे हो?
हाँ जी सर।
हाँ जी, हाँ जी, आपसे बात हुई थी। ठीक है जी।
ठीक है सर।
सर आइटम 4 में भी मैं प्लेंटिफ के लिए हूँ।
SCL
आई थिंक डिफेंडेंट्स के लिए भी है।
ठीक है, पहले मैं MGM पेपर हूँ। सर प्रोनाउंसमेंट है ना आफ्टर डीवी होगी। गोयल मैडम जी प्रोनाउंसमेंट आफ्टर डीवी होगी, ठीक है मैडम जी।
सर कितने बजे सर बैठेंगी मैम?
सर बस ये 2-3 मैटर है, उसके बाद प्रोनाउंसमेंट होगी, डीवी के मैटर आ रहे हैं प्रेस कोई।
डीबी है, ठीक है ठीक है,
हाँ
कोई
जी,
बात नहीं सर,
बस पास आधे 15-20 मिनट में हो जाएगी।
कोई बात नहीं सर, कोई बात
ठीक, ओके ओके।
ओके सर।
डीवी के यहाँ से वहां पे नहीं उतारे आपने, जहाँ से आप चलाओगे। अरे फिर वही बात करो, मार्किंग का 2 जगह कराओगे। तो ब्लोवर चला रखा है, ब्लोवर चला हुआ है। अरे जहां से एसी चलता है वहीं से ब्लोवर चलता है। कंट्रोल सी जनाब, आप ये खोलोगे ना, इसी को खोल दो ना, इसी को खोल दो ना 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 नहीं, नहीं। यही खोलो ना, इसमें मार्किंग तो वापस लाइन पे लगा दी थी मैंने, सारे आ गए। इनको इसमें रख देना, लाइन से है बस, ठीक है बाद में देखेंगे। चार 4 मीटर है डीबी के डॉक्यूमेंट बना तो रहे हैं। हाँ फाइल से
ये इसके साथ लगा के
ला दो।
तो ये पेज 1
क्या इसके साथ ही इसके साथ ही सर। ऐसे
आप ये पहले कहते मेरे को संभल
नहीं नहीं, मेरे पे इनका तो था, मुझे थोड़ी पता ही उनके साथ है, इनका तो मेरे ठीक है।
Your Honor, I mentioned one matter, my lords.
Yes.
There's one urgent mentioning, my lords. Actually, my limitation is expiring on 1st of January, my lords. I filed my application seeking extension of that time limit for extension, my lords. So Saturday, I filed my application.
In which jurisdiction is the limitation expiring?
My lords, no, there was an order for execution of the local commission. However, due to the holidays in the office, we cannot get the order executed, my lords, because it will not serve the purpose. Therefore, I moved an application.
Passed by which bench?
My lords, by Justice Mini Pushkarna. That order was for the. It's an LC matter, my lords, copyright infringement matter.
Why could you not execute your order?
My lords, the issue was that between between 26th to 2nd of January, that premises would be, there are holidays, ongoing holidays due to New Year. So therefore, my lords, it will not serve the.
Did you find out that it would be on a holiday?
My lords, we had time.
Make out a justification for a vacation listing. So please quickly tell me.
Yes, my
When
lords.
did you find out that the premises would be unavailable?
My lords, on 18th, the order was passed, and we had time on 20th, between 24th to 23rd only, we got to know that that premises, everyone in the office.
Time from 18th onwards to
From
execute.
18th to 24th, we could not execute it, my lords, because we were in search of the other location also, my lords. Therefore, we.
You come on 3rd January. The court will see on 3rd January. Please have it listed.
My lords, on 1st January, it will expire, my lords, my limitation.
You should have done it within the time you were granted. Let it come on 3rd January.
Item number 5.
Yes.
Leadership, item number 5, I appear for the Income Tax Department. This copy of this application has not been served on us. However, it's a disposed of writ
What
petition.
is this? What is this? Why you? I mean, he's mentioning a matter and you are arguing without the bench even having the file before it. Just wait, sir, please. So you are appearing in which matter?
So I filed a fresh IA in already listed, file case before this honorable court. What has happened is, ma'am,
Mentioning for listing or are you?
It's mentioning for listing, ma'am.
Yes, tell me.
An injunction was passed by this honorable court whereby my business has been injuncted, whereas I am in a business of bespoke model, bespoke products, ma'am.
When were you served with a copy of the order?
On December 12th, ma'am.
12th, no?
12th December,
I
ma'am.
can't hear it today. Let it come on 3rd January, okay? Follow up next. Yes, madam.
It's two bail applications. Leadership, in this, the bail application was dismissed by the vacation bench of learned ASJ Tisagari, FTC, on 26th of December, leadership, and thereafter we have to move. The urgency is that there were 4 accused. Out of that, 2 were arrested when they turned up for investigation. 23rd of December, when they tried to join the investigation, they were summoned with a notice of 19th of December. When they joined on 23rd of December, 2 of the accused were arrested. We are talking to other accused. So we are moving the bail application.
An anticipatory bail application.
Yes, leadership. It was dismissed on 26th of December in Tisagari, vacation bench.
Okay, all right.
Item number 5, please.
This is an application seeking urgent hearing as well as stay on the reassessment proceedings. For that, we will give the brief background of the case. This is the review petition filed in pursuance of the liberty granted by the Supreme Court in the FLP to have the order under review reconsidered in the view of judgment passed in India versus Rajiv Bansal. Because in this case, Section 148A of the income tax has not been complied with. Recently, what is the urgency? The order passed by the Supreme Court is also annexed as Annexure A. The urgency in the matter is that I have received a notice on 23rd of December that shows the proposed variation that has to be added in my case. So I do not object to filing the reply. I will file the reply to that, but just I am seeking that no final order of assessment be passed till next date of hearing. It is on 24th January. On previous.
Do you say, Mr. Shlok?
Yes, leadership, this is what they have cited before the Supreme Court has no bearing on the facts of the case.
That's okay, but I can't decide that. No, that the division bench will decide on 24th January. In the meantime, what do we do to protect your interest and the petitioner's interest both?
Leadership may allow the hearing and have a hearing and may list it before the roster bench on 7th.
Yes, but in the meantime, they will file a reply, and what will you do? You will pass the final order after the next date of hearing.
After the next date of hearing, I'll inform the officer that he
No final
stays
order
his hands
will
till
be
7th.
passed until the next date of hearing, right?
Yes, that's correct. I'll do that.
Is your limitation going to expire in this matter on 31st December? You have
No
limitation till what time?
We have limitation. It's not expiring on 31st. And in any case, if leadership is saying that not pass an order, that limitation will get extended.
Okay.
So,
all right. Just say CM application 76671 of 2024. This is an application filed by the review petitioner, seeking stay of the show cause notice dated 23rd December 2024. Learned counsel for the petitioner states that the reply to the show cause notice will be filed on or before 31st December 2024. He, however, prays that so as to not render infructuous the review petition number 434 of 2024, the respondent be directed to defer passing the final order. Learned counsel for the respondent accepts notice. Good stop. He prays that the date before the roster bench be preponed, right? It's before the roster bench.
Leadership, the review would now come up before the special bench. It would not be before the roster bench. The review would come before the special bench.
States that the date before the special bench be preponed so as to enable. I don't think I'll be able to prepone it, Mr. Shlok. Let's have it on 24th January only. It's a
Very
special
well.
bench. Okay.
I understand.
In view of the aforesaid submissions, the petitioner, the respondent is directed to defer passing of the final orders until 24th January 2025.
Very great.
Item number 6.
You are appearing for which respondent in this matter?
Because I'm appearing for state Miller's one.
So you're appearing for respondent number 1.
NCT of Delhi, please.
Yes, I know. So you're appearing only for respondent number 1.
That's right.
Who will be appearing for the SHO?
Numbers 1, 2. As far as
Will appear for 2 also, no?
that's right.
You are appearing for respondent number 2 also. What are your instructions?
Because they are not in Delhi, admittedly. They have been taken by UP police. So in my respective submission, not maintainable evidence. It has to be UP.
But, I mean, I understand, but what is your information? You must have done at least some investigation.
Unofficially, what we have been communicated by the IO from UP, the girl is about to give a statement of section 164 and she is not against him. So therefore, he has been released by the police and he is in custody of his relative in the village itself.
Custody of which? So the relative is in Bulandshahr.
That's right.
Whose relative? The boy's relative? or
Boy's
son?
relative.
So have they been able to make contact?
Because that we don't know. They have registered a case over there. So where the girl has been, would be produced before the concerned magistrate for 164. Although as far as 161 is concerned, she has supported the petitioner.
The statement before me when I was sitting in Federal, that the girl has already made a statement. Why is was about to be recorded?
Because to the police, yes, that's what I submitted before my lord. As far as 161 is concerned, 164 would be recorded.
Of the girl, no?
Of the girl. And she has been sent to one-stop center.
Yes, sir. What do you have to say?
Girls living in Delhi Lordship, they are missing from Delhi Lordship, and they are saying that
That's okay, but
अभी इन्होंने बताया कि वो अपने जी किसी रिश्तेदार के हैं, लड़के उनके जो परिवार वाले माता जी यहीं भी कोर्ट में प्रेजेंट है, तो अपने किस रिश्तेदार के हैं? लड़के दूसरे कहते हैं कि स्टेटमेंट हो चुका है.
First tell us the jurisdiction issue, because he's saying that he's confirmed it unofficially. They are in Bulandshahr and you spoke to the SHO of PS Sikandrabad, right?
That's right.
We have spoken, he's there. So how does this court exercise jurisdiction? Just assist us on that. Yes. How do we do this?
Lordship, boys and girls are missing from Delhi Lordship, and Lordship, as per my knowledge, Lordship, boys and girls, neither the Lordship PC nor JC Lordship. अब ये कहते हैं कि किसी रिश्तेदार के यहाँ हैं. Lordship किस रिश्तेदार के हैं?
बोल रहे हैं वो ये कह रहे हैं कि वो यूपी में है और आप दिल्ली हाई कोर्ट हो, तो ये पूछ रहे हैं कि आपकी जुरिस्डिक्शन कैसे है इस थाना यूपी को नोटिस इशू करने के लिए, क्योंकि इनके कब्जे में नहीं है वो, उनके हम स्टेटमेंट रिकॉर्ड कर लेंगे, इनकी कस्टडी में नहीं है।
बट मैं इनके कब्जे में है, मैं कह रहा हूं कब्जे में नहीं, लेकिन वो जो गए हैं दिल्ली से मिसिंग, और फिर उसके बाद आज तक वो ना ही तो ये थाने पहुंचे हैं, कोतवाली जो कह रहे हैं सिकंदराबाद, बॉयज तो लड़से वहां पर है ही नहीं, वहां पहुंचे।
मैं पास ओवर कर देती हूँ, आप प्लीज हमें कोई दिखा दीजिए जजमेंट जो हम जुरिस्डिक्शन एक्सरसाइज कर सकते हैं कि हम पुलिस स्टेशन यूपी को कर सके, पास ओवर कर देते हैं, आप दिखा दीजिए।
हमें यूपी को करने की जरूरत है, क्योंकि वो उनके वो बॉयज और गर्ल्स लड़के मिसिंग दिल्ली से हुए हैं, इसलिए तो दिल्ली
Just a minute, please. Kindly wait, sir. Yes.
No, it is a wrong statement, therefore I.
Yes.
देखिए, they are missing from दिल्ली लॉट से। अब अगर वो यूपी पुलिस से कहते हैं कि ले गए हैं, तो जनाब इनके थाने में तो कहीं एंट्री होगी, जीडी एंट्री होनी चाहिए। लॉट से प्रॉब्लम ये है कि वो बॉयज और गर्ल्स लॉट से नहीं तो वो वहां पर थाने पहुंचे लॉट से।
आप चाहते हो कि इनसे स्टेटस रिपोर्ट लें?
He is absolutely right. He has made the DD entry.
अगर ये कह रहे हैं कि इनको पता है किस रिश्तेदार के हैं, लॉट से उनको ये कॉल भी करके इनको भी कोर्ट के आगे पेश करा सकते हैं।
अच्छा, ठीक है, डीडी एंट्री दिखाओ।
DD entry, by virtue of this DD entry, UP police has taken them this.
रात 3:30 बजे दिल्ली पुलिस इनके घर पे जाती है, इनको अरेस्ट करने के लिए 3 बजे लॉट से, और कहते हैं कि हम स्टेटमेंट लेने आए। लॉट से 3:30 बजे 1 बजे 3:30 बजे इनके कौन सा मतलब लेना है स्टेटमेंट लेना है लॉट से 3 बजे लॉट से रात को। लड़की की जब माता जी 3 बजे रात को दिल्ली पुलिस पहुंचते कि हमें आपके लेने स्टेटमेंट लेने।
सर आप डिसाइड कर लीजिए, आप दोनों में से किसको बहस करनी है, आप डिसाइड कर लीजिए, उसके बाद आप बहस कर लीजिए।
लॉट से मैं वही कह रहा हूँ, क्योंकि वो जो मिसिंग दिल्ली से है लॉट से, और कोतवाली यूपी कोतवाली में जो इनका बेटा लॉट से, उसकी कहीं पे एंट्री ही नहीं है। अगर वो यहाँ से पुलिस ले गई वहां पे एंट्री होगी, एंट्री नहीं है सर वहां कोई। प्रॉब्लम है लॉट से हिंदू और मुस्लिम का मैटर लॉट से, और यूपी पुलिस इसमें लॉट से जो लॉ है उससे भी ऊपर चली जाती है लॉट से। 3 दिन हो गए लॉट से भी इनको गए हुए।
Then it have to be resident commissioner. Resident commissioner.
You'll file a status report also.
We'll do that.
Okay. Mr. Right. By way of the present petition, the petitioner is seeking a direction in the nature of habeas corpus directing respondents to produce her son, i.e. Dipanshu Yadav, and daughter-in-law, i.e. Roshal. Learned counsel appearing for petitioner submits that son of the petitioner and daughter-in-law, along with the petitioner, were taken into custody on 27 December 2024, and thereafter the petitioner alone was released. He states that since then the son and daughter-in-law are missing and are in the illegal custody of the respondents. He states that the son is aged 19.5 years and daughter-in-law is aged 20 years. Issue notice. Learned counsel for respondent numbers 1 and 2 accept notice. Issue notice to the resident commissioner, Uttar Pradesh.
That's it.
Or issue notice to respondent number 3 and 4 to resident commissioner, Uttar Pradesh. In addition, SHO Mandarmarg is also directed to send an intimation to the respondent number 3 and 4 for the next date of hearing with the direction to the said with the direction to the concerned officer from PS Sikandrabad to remain present along with a status report. Issue notice to respondent number 5 to the respondent number to the concerned SHO. list on, so we'll have it on 3rd January. List on 3rd January. This one number 1 and 2 shall file a status report, and this one number 3 and 4 shall also file a.
Can I get order dusty under the signature of courtmaster? First to
The copy of the order be given dusty to the parties under the signature of the courtmaster.
Oh, great.
Item number 7.
My cousin brother has died.
So where are the respondents? Please call them.
Respondent.
Those in this without those. You are appearing, sir?
Yes.
Yes, sir. What do you have to say in this matter?
We have verified the factum of death in the theory. The difficulty is he's a remote relative. But I am not very sure. His interim suspension has been decided by this honorable court on 12th of December 2024. And before that, on 16th of October 24, his regular suspension was dismissed. It's a case of honor killing.
16th October, regular
suspension, and then 12th of December, his interim suspension.
My lord, it is a wrong statement.
Just a minute, sir. Please. Table tennis match. Yes.
It's a case of honor killing.
Yes.
His entire family is involved in killing a person. There are 6 accused, 5 from same.
And it was done by the roster bench on 16th October and 12th December.
That's right.
Lord,
The same bench.
Same bench.
Lord, the same bench has given me bail, interim bail as well.
18 July.
18 July, my lord, and it has been extended.
Let it come before the roster bench.
Lordship, let me
Yes.
insist on this scenario. Lord, the
So
theory is
either
on,
we dismiss it or we place it before the roster.
Lordship, the theory is on 3rd.
I understand that.
But the
So we have 2 options. Either we dismiss it or we place it before the roster bench.
Lordship, if I may be allowed to make out.
Make that choice, then we'll hear you because we have to deal with it. So you make that choice. Either it goes to roster bench or we dismiss it.
Lordship, it will become infructuous the moment we go to the roster.
Infructuous because your purpose is different, which will get still achieved.
My lord, the purpose, I'll explain to you, Lordship. The theory is on 3rd, my lord.
First, take instructions. We are either hearing and dismissing it or we are placing it before the roster bench. We are otherwise not going to spend time.
Then, my lord, I will withdraw it.
Yes. This whatever the application number is, 22312024. After some arguments, learned counsel for the applicant petitioner seeks leave to withdraw the application. Application is dismissed as well.
It's on record, status report.
Learned counsel, learned APP has handed over status report dated 30th December 2024 with an advance copy to
Yes,
the
sir. It was, sir.
applicant. The same is, he is directed to have the same placed on record.
Item number 8.
Milord, I am from R1 to R4 from Union of India. We have already issued promotion order today of the batch of 2024-21 as per the direction of Honorable CAT, Delhi on dated 23/12/2024. The department officer is there physically. The dispute is regarding to the vacancy of year 2022 or later years, which does not have any concern with batch number 22. We are ready to reserve proper seats for applicants OA 1864 to 23 if DPC of other suitable candidates is allowed for vacancy year 2022 or later. As per direction, as Honorable Court given, we will do that.
Madam, just I have understood the part of 2021 and 23rd December. Just repeat your submission on 2022. Please repeat whatever you just said with respect to 2022. Madam,
The dispute is regarding
Ma'am, the petitioners in the OA 1864 are 2022 appointees? No. Ma'am, please, just let her answer. Counsel for the respondent.
No. Actually, as the direction of the Honorable Court, that was regarding to batch number 2022-21. That we has done.
Yes, madam, but
As
the petitioners in OA number 1864 of 2023, they are seeking their right of promotion with the batch of 2022.
Right, madam.
Actually we are ready to do that as the direction of the Honorable Court.
Can I clarify? You will clarify. Will you just wait? She's opened it, no? First, let me understand her submission. Then we'll come to you, madam. It's your petition. I'm sorry. Counsel for the respondent, please tell me whatever instructions you have for 2022. You will reserve these seats for respondent, the petitioners who are in the OA, is it?
Yeah, we will reserve as our DPT department will be allowed, and we will do for the suitable, which is favor for them.
What does that mean, madam? What does this mean, suitable?
We are ready for proper seats for applicant OA 1864-2023.
Okay, fine. Who's appearing for the petitioners of the OA?
Yes, I am appearing. Lordship, the dispute is in fact the petitioner before Lordships and official respondent, they are on the same page. So they were
That's
one
all
in
right,
the.
sir. That's okay. They are in the same page.
Now,
You
my
please tell
lord,
us your
my
concern.
submission is that these petitioner, Lordship, would see the who has filed the petition, see their application for implement 316. They are junior to us. And those facts they have not at all disclosed. Lordship, just have a look at page 316, their implement application.
Okay, sir, they are junior to you. It's all right,
Yes.
but they are not in litigation. So what I want to ask you is that the relief which is being prayed for by the Union of India that permit me to carry out the DPC and I will reserve the seats for the petitioners in the OA. Why is that not protecting your interest?
My submission before Lordship is we are to be promoted prior to these people. If they are promoted ultimately today, so they would be now in the promotional grade also, they would be senior to us. So my submission is this would be allowing the illegality to be perpetuated. So already they have been given march over us. Now this would be second layer.
No, that's okay, sir. So please tell me, I understand your concern. You have obviously you have even succeeded before the tribunal, so you can't be at a disadvantage.
Correct.
But you have succeeded, and by the time your review gets decided, we can't hold these people to ransom. So tell me, how can your interest be protected in addition to reserving vacancies? That is not sufficient according to you.
No, either we should also be promoted. Now we cannot be now already. This is the third round of litigation. The Bombay bench, Kolkata bench, already allowed the petitions. Now the principal bench on technical point it was reviewed. Otherwise, there are already two judgments. Now instead of implementing our order, in spite of having an order for 6 months, the government now want to promote these very people who are ultimately junior to us. Lordship, I have the seniority list. It is at page
Now
number
tell me one thing, counsel for the petitioner. I'm again asking you. Otherwise, then I'll ask the petitioner and I'll stop listening to you. So I'm asking you the last time.
My lord.
They are saying that we will reserve requisite number of vacancies vacant subject to the outcome. They have offered this. In addition to this, what is the other restriction which can be imposed to protect your interest?
Either we can also be promoted, but that is the vacancy is not an issue because vacancies are last number. Now they are saying that we'll reserve the vacancies. That will, vacancies are already enough. So this is the way. It's not some kind of protection they're giving to us. This is the already there. So that's why Lordship.
So how can you be protected? Okay, you don't think this is a requisite protection?
Yes. So either we should also be promoted as office superintendent along with us because they are junior to us. And if Lordship would see page number 316, that implement application, they are nowhere even explaining in that application the correct factual position. That's why that application was not even allowed by the tribunal. We have their application 316 at page number.
If they were junior to you, then
Yes.
why is it that you are in litigation and they are not?
Yes, what happened is that these petitioner and we all joined as MTS through Staff Selection Commission. So we are direct recruit MTS. They are much below in that list. Now promotions are to the tax assistant. So when the promotions are made on the basis of tax assistant, it has to be as per the seniority of MTS. But what happened? The government did not follow that seniority of the tax MTS, and the people who are below, they were promoted. So we approached the tribunal, not only we, Bombay bench, also the people, Kolkata, all of where litigation started. That how someone who is junior in the ranking given by SSC be promoted first. So that dispute arose and the OAs were allowed. So it is only that in our case, technically the summer was not served, they withdrew that order. So otherwise, we would have got promotion instead of these very people.
When is the next date of hearing before the tribunal? 29th of January.
And Malas, nothing will happen even if the promotions are made later. The government can take care of everyone. It's not that, see, that interim they're seeking. They're seeking that you give direction to hold a DPC and promote them. Malas, their position has to be seen, their seniority has to be seen, and there's so many factors, Malas, who are ultimately would be affected. My submission, Malas, we should be, because the entire, and that's why in the MA, they don't give the details. Let me see that MA, page 316.
Okay. Yes, madam. What do you have to say?
Milords, 2019, all of us joined as MTS. 2022, Milords, we get promoted, they don't get promoted. Now, Milords, 2022.
Why do they don't get promoted? And
They
why
don't
do you get promoted?
Yes, Milords. Because 2022, in order to get promotion, Milords, there were two factors that were operating. One were the recruitment rules, and the other was an executive instruction which said that in addition, the recruitment rules said three things. One, you have
Madam, there was RR and execution instruction.
Yes. Now, Milords, these executive instructions continue till 31st of May 2023.
Yes.
And I get promoted in 22.
Yes.
When I get promoted, the executive instructions were in place and they were not fulfilling the executive instructions.
Okay.
They don't get promoted. Eventually, Milord, what happens? They go to the tribunal saying that please protect us. Tribunal only gives them the limited relief that their representation should be disposed of. They don't challenge that. Now, because that representation gets decided, so they challenge the representation in the speaking order in a second OA. In the meantime, I become eligible for the next promotion. Now, Milords, today, if your lordship will see, he has become eligible in 24. I have become eligible in 22. So till the OA is decided by the tribunal, they want to hold everybody's promotion, Milords, for no reason at all.
Okay, madam, so you please tell me, in case they were to finally succeed in their petition.
Yes.
Let's assume that all your arguments get rejected.
Yes.
And they will have to be also brought back into the same position as you. He has not answered that question, that except for reserving vacancies, how can he be protected?
Yes,
so you please give me that answer.
Yes, I'll give that answer. Because if your lordship will see the memo of parties for a minute.
Madam, just tell me, no?
Yes, I'm telling you, Milords.
Yes.
Lordship, there are 25 people. And all of their seniority number, Milords, if they succeed, how will they succeed, Milords? Because then it has to be as per rank. Now, Milords, I am above them in the rank also. So, Milords, because I'm higher up above them in the rank, so even if the promotion happens as per their choice and the OA is allowed, even then I get promoted. My promotion does not get disturbed under any circumstances whatsoever. That is why I was showing from the seniority list, Milords, they are at serial number 600, 700, whereas I am much above them in 592, 594. So, Milords, I'm above them. So my promotion will not get disturbed, whether it is 2022 promotion, whether it
It's
is
your statement that even if their order is implemented in entirety, it will not in any manner affect the seniority list. Is that your submission?
It will not hamper the eligibility of mine. Seniority, Milords, will come later on.
No, madam, we have to decide today, no? If we give any relief in your favor,
yes, Milords,
we have to see, will it, if their order is implemented, does it in any manner affect your eligibility? You've answered it will not affect.
Yes.
What about the ranking and the seniority?
Milords, that will be subject to the OA. The OA is not
But it is assumed today the OA has got allowed.
Yes, Milords.
Because we have to today give you an interim order where if the OA gets allowed, it also has to be true. So how will that OA work when?
How will that OA work? Because we both get promoted in that circumstances. I also get.
And madam, does it affect the seniority, madam?
It affects only for the rest, not for us. Because it affects, Milords, there are 25 people. I'm only 4. And I am above them. Milords, my seniority number is 593, 610, 612. They are below that. So, Milords, even if my seniority gets affected, I go down only by one position, one rank. Whereas, they go, Milords, so Milords, even if this
one of them will come above you.
One of them only.
Which petitioner will come above you?
Milords, 584 seniority number, 592 seniority number.
So there is somebody at 584, 592 from their list who will come above.
Will come above.
So you're willing to give that statement that you will accept it?
Of course, yes. It has to. If the OA is allowed, seniority can be as it is as per law. I have no difficulty with that.
That not only will seats be reserved and seniority will be as per law, and you will not object at that stage.
We will not object to it, Milords, because it has to be, Milords, whatever is as per law, it has to fall like that only.
Ma'am, but I need your concession.
Yes, I have.
You will not object at that stage to the seniority.
Seniority as per law.
Madam, for Union of India.
May not give a small date, then we can discuss
Madam,
with the
not
staff,
only-
with the
not
department.
only will you not only will you reserve the seats, but also we record their concession that they will also accept that any changes in seniority which have to be affected, they will not challenge that change in seniority. Counsel for the petitioners in OA. Yes.
Yes, may I submit one thing subject to my lord's approval? Malas, what my friend has argued that their seniority is not going to be affected. Lordship may just see that their seniority is at 5, 96, 93, 609, 610 and 612. Now, Malas, we are above them. Now, today, if the promotions are
only two people are above them, no? 584 and 592.
And 588 also, Malas, 588.
Okay, 584, 588 and
592. And Lordship may kindly appreciate it is now not only that the seniority at a level of tax assistant.
Yes.
Mala, the dispute, now the issue would be Mala, that office superintendent, because now the DPCs are being taking place. So for the other people, it is already done. So the DP has already happened. Now the next DPC, when they will have the losses, let everyone be considered because DPC is not scheduled now. So as of date, there is no urgency for them. Also, DPC already taken place, order issued by them. Now the next DPC would be now, whenever they'll happen it, they will consider us also. Because today, Lordship, their interim order was that to issue a direction to consider. Now DPC, as per the Government Council, DPC already held. Promotion order also issued.
I understand. Just answer one thing, but if they reserve the seats, and if Madam's statement is recorded that she will not challenge the effect on the seniority list, then why should the DPC not go through whenever it will happen? Whenever it is going to happen, whenever you know.
So, now the date of DPC, by the time the OA is now coming up next, immediately first week, Lordship put it next day, and we are ready to argue. Even on that date also, we requested Lordship may hear the OA. Why to give interim order? We are ready to argue. Because we are, this is our third round of litigation, Lordship would say.
Council for Union of India, when is the next DPC scheduled? Madam, I can't hear you. When is your next DPC scheduled?
According to give the next small date and then we can discuss with the department. Actually, we are on. I am online and department officer is on the physical. So
Okay,
we are not able to talk.
I will ask him, Madam. When is your next DPC scheduled?
मैम शेड्यूल सिर्फ दिसंबर में होती है मेन डीपीसी उसके बेस पे जो भी ऑर्डर आता है उसके बेसिस पे हम रिवाइज डीपीसी करते हैं मैम
तो अब डीपीसी हो गई है अब आपको जब कोर्ट ऑर्डर करेगा तभी आप करेंगे
Because if there is a direction from the court, that is what I suppose.
Action.
There's one more thing.
Revised DPC have you issued a notice for revised DPC?
Because just one thing I wanted to say, that they have held the DPC because as per the order of the tribunal. We have not been considered because of the order of the tribunal. Today, if my lords will direct, they will consider us. Now, my lords, two more small things. One is that when Mr. Bhardwaj said 588, because when Mr. Bhardwaj said 588, that is incorrect because 588 is an SC category. We are all general category candidates. So that will not come above us. And the second thing is that, my lords, they are saying, my lords, that DPC can be, the matter can be heard over the tribunal.
Madam, since anyways the date of DPC is gone, I'll list it before the roster bench on 7th January. Let the roster bench decide this. In the meantime, I'll record their statement that they're willing to hold it. And I'll record your statement that you're willing to agree for a seniority impact.
So can I just show your lordship only page 304? 302 minutes.
Okay.
My lords have got it.
Just a minute. Yes.
Number, please. This is the application of the government news. I'll just give the annexure number. Because this is annexure number 297. Starts from 293. May I just read 302 minutes? Para 4 your lordship will have. That it is submitted.
Item 8 annexure.
Serial number is P7. Yes.
Yes.
Plus 3 lordships have got it.
Yes, ma'am.
It says para 4, it is submitted that halting the promotion process will have severe negative impact as such. A, the delay in promoting approximately 200 employees to the post of office superintendent will severely impact their future career advancement, as 1st January is the critical date for calculating eligibility service for higher positions. If these promotions are not implemented by 1/1/25, employees will lose an entire year of eligibility service, resulting in significant setback to their career progression. Additionally, employees due for promotion may miss out financial benefits associated with the higher post. The applicants in the OA will also lose 1 year of their eligibility service if promotion is not implemented by 1/1/2005. And delay in promotion will create a cascading effect on the subsequent promotion in the lower post, such as tax assistant, notice server impact. So, what I'm trying to say is that if I'm not promoted by third, my promotion can be subject to outcome. My seniority can be subject to outcome. The government is willing to accommodate by keeping post reserved for them. Let the review DPC happen, milords. Nobody is going to suffer because of this. It's only me who's going to suffer.
Madam, what about the petitioners who have succeeded on 30th April? Are they not suffering?
No, they are, today also if we see, if they have to be promoted, posts are being kept for them. So far as they are concerned, their rights are not getting affected in any manner. Number two,
why not this 1st January 2025 does not apply to them?
They have to have 3 years of service also. So first of all, their promotion as a tax assistant has to be given.
It equally applies to them. It equally applies to them.
Today, if I am promoted, tomorrow, if there is a problem, they can take a remedial action. But today, if I am not promoted, the clock can't be turned back. So far as they are concerned, they are in litigation. I am not in litigation,
Madam, how many petitioners are affected by that impugned order?
We here,
No, not you. Otherwise, how many other parties have not been given the benefit of this OS, the office superintendent promotion? How many other petitioners are affected?
150 people are affected.
Before me, there are only 4. Right?
Yes, 150 people are affected.
They have to hold a review DPC for all of them.
They have to hold a review DPC for all of them. They can keep 25 people. Although, my lords, it's a matter of record that 5 people out of those 25 haven't even cleared the test which is required for office superintendent promotion. We leave that also aside, my lords. Let them suffer their own fate. 25 posts can be kept. Because let us 150 people suffering for 20 people here.
Madam, I'm just not being able to get a clear answer from you and Mr. Bharadwaj how to protect the interests of 25. Both of you are giving me half facts. And so you only are looking at your petition and he's only looking at his petition. None of you are willing to explain.
I'll try and explain, Milords. How is an employee suffering? Because of promotion and because of seniority?
Tell me, how is Mr. Bharadwaj's client suffering?
Them only,
yes.
There are 2 things. One is promotion, the other is seniority. If both promotion and seniority of Mr. Bharadwaj's clients are protected, then they have all the protection. What under law is available to them? Let him say. We will answer. What under law is available?
Lordships, what my lords have said, I think no further lordships have rightly said that this 1st January is equally important for me also. I already got a favorable order in April. My friend is just concerned about her clients only. So when lordship said that
now
this
tell
equally
me one
important,
thing, madam, are you opposing the implementation of order dated 30th April? Are you opposing implementation of order dated 30th April? Because see, madam, that's where the problem is coming. Tribunal has already passed an order, but certain applicants are going and opposing it. That order is not getting implemented. But in the meantime, your promotion has come up. You want your promotion should go ahead, but their order should be reviewed again, correct?
Because I did not go for the review. Somebody else went for the review.
Yes.
Because if government's stand is seen from the order sheet, they have said that the applicants did not bring it to the notice of the tribunal that these services were to be effected through the government. They did not take any effort. How is it possible, my lords, that the entire tenure of the original application goes on and the applicants don't point it out to the court that, my lords, private response?
Madam, I'm asking you a simple question, madam. Is it correct that you are going to oppose the implementation of 30th April 2024 order when you go back in OA?
Because to
So,
answer,
see, madam, we have to understand, no?
Yes.
Orders have to be implemented. Orders can't be kept in abeyance.
yes, ma'am.
We can't, just as you are getting heard by 16 December, those petitioners are getting heard by 30th April, not getting implemented. And that is the reason the tribunal wants to hear everyone together.
Because I go down to that. Now the
Madam, when is the tribunal going to reopening? We can prepone the hearing before then. When is the tribunal reopening?
Reopening on 2nd of December, they are reopening, Malas, Tuesday.
December is gone.
January, madam.
Sorry, January.
2nd of January, Malas, the tribunal, Malas, but with regard to 1st of January, that is my problem. Malas.
And review DPG can be.
Madam,
held for everyone.
I can make this observation that subject to the final outcome of OA, whenever this DPC will be considered, you will be given, it will be effective 1st January. I can make
Malas, that would be perfect for everyone. Losses is
And my
there.
financial benefits, Malas, they will not be taken care of. Malas, today I don't stand to lose, Malas, on the
But
final.
what can we do? You are opposing 30th April also, no? Everybody's interest has to be balanced.
Even for that matter, even if I don't 30th April, because the point is that 30th April was passed without even making me a party. So, the tribunal in its wisdom has reopened in the OA to hear everybody who's a party. So, respondent number 5 to 16 were also not heard there. It is not me. I was, and one important thing is that they had probably in their well understanding did not make me a party, because they know very well that my promotion is not going to come in their way. They made respondent number 5 to 16 parties because they will be affected by them, not by us.
Okay,
Madam,
madam,
make that 1st of January equally important.
madam, either you take a stand, you will not object to 30th April. Then I will record this, because madam, it can't be possible that you are giving that concession that yes, I will not object to seniority, I will not object to reservation, but I will object to 30th April. I don't think it's consistent, madam.
If it
Just may make it 1st January, Malas, that will protect everyone.
To be honest, Malas, 30th April order is now gone.
No, madam, 30th April will be, the review has been entertained. It's not even allowed.
It is allowed. So now there is no order which is prevailing against me and in his favor. The tribunal wants to hear it afresh. And Malas, the tribunal will have to, in any circumstances, give an opportunity of hearing.
There is already a Bombay bench judgment, Malas, on technical point. One judgment has been reviewed. Kolkata bench, Bombay bench already implemented.
Because they took an order from the tribunal without.
Losses may be that the 1st January losses may keep it intact for everyone. 1st January, Malas, that will.
Please may allow.
Okay. Madam, how much time do you need for holding a review DPC? Counsel for Respondent Union of India, how much time do you need for holding a review DPC? How much time do you need for holding a review DPC for these candidates, for these petitioners?
So, ma'am, अभी इसमें it depends. इनकी अगर विजिलेंस और वो आ चुकी होगी ऑलरेडी तो हम जल्दी कर सकते हैं 2-3 दिन में भी. अगर इनकी विजिलेंस नहीं आई,
विजिलेंस has come.
विजिलेंस आ गई है.
आ गई है.
आपकी तरफ नोटिस इशू करना 15 दिन में हो जाती है.
यस,
ठीक है, विजिलेंस तो आई गई है.
15 days में हो जाएगी.
Mr. Bharda, we reserve your rights for the vacancies and also their statement that they undertake, they understand that there will be, the seniority list will be affected if petition, which are those 588, 584, 588 and 590?
Malas will put it, prepone the date and let the 1st January be kept intact for everyone, because that would, otherwise, Malas, my OA disposal would be again delayed, because that this all happened because that order was passed by the tribunal.
Okay, just tell me who are the respondent numbers who have 584, 588 and 592?
Lordship will get it. Page 141, Lordship will get it. Here's 141. Plus serial number 70 is the seniority number 584.
I'm just telling the respondent number over here, no?
Yes, that I'm giving you. Because one is serial number 584 Narayan, and the other person who will go before me is 592 Kailash Kumar.
588, Mr. Bharadwaj was pointing out.
That is SC category. We are all general. So 588, Berchand, Barabas, promotion, seniority, nothing affects us. Narayan is general.
Madam, how many petitioners before us? 4 petitioners. 5 petitioners.
We are 5, Milord.
But madam, the stay order has affected how many applicants?
150. Because out of
150 are bound to come here, no?
Milord, that's why, Milord, the fair submission was made by the government that let's keep 25 posts reserved for them and let's go ahead with the promotions.
DPC is now already
made.
had.
Milord, I don't know if his rights are protected, why is he?
We are not only 25. The equal group is decided also. Only 25 approached. So the people who are affected there equally that side. Not everyone has come to the court. So it's not that we are only 25. So 25 are litigating, but equally people are affected that side also. So Lordship may put it malas immediate reopening because now DPC has already held. It has to be a now review DPC only, which again they have to fix a date. So now the DPC would take care of the 1st of January because now the DPC has had permission already issued. So again they have to hold a DPC.
That's why government had said requisite number. They will know
so
better.
That's what I'm. So Lordship put it
we and I argue on this. Government knows better that how many posts are to be kept vacant. They will keep the rest can be.
This will administratively create a big issue because I don't know how many people.
Rights, we have stated in our petition that without any prejudice to
Madam is just concerned about her because she is not giving complete figure. 25
they
are only
just want a blanket stay without allowing anybody's promotion to happen.
Not only everybody promotion, we are waiting for 6 months now. Our OA was allowed, government did not implement that.
If they are waiting for 6 months.
So now Lordship
I
put
have
it
become eligible in 2022, my lords. And my lords, I am due for promotion. I fulfill all the eligibility criteria.
Now the DPC has to be held for everyone, not only for these now. Because DPC has already had permission already issued. So put it, 2nd of January, it can be argued. We are ready to deal.
My lords, in all fairness, can be subject to outcome of the OA only if they succeed, they will be promoted. But my lords, still, if that doesn't happen for 2 years, my lords, I am held up.
So they're just concerned about there because ultimately the people are both the sides are waiting and we are the senior people. And my friend has said that
from the seniority list, they are not senior to us.
And Lordship would say they made a wrong statement that we are because executive instruction continue.
1 minute.
Let me, madam.
Just see, my lords, page 56 for 1 second, my lords. Just see page 56.
She's 22. She the order is affecting one, but she the next careful and simple. Giving you the statement. We have to modify the order. Every state they can't do it. We have to modify the order. Can I just show? Council for Union of India, just tell me one thing, that this submission that the council is making, that from 1st January 2025, if the DPC is held after, let's say, after 29 January, and even if you grant them promotion, this entire year of service will be lost. Is this correct?
Not at all.
Miss Council for Union of India?
Milord, actually, as per the order we did it. As per the order we did, as order was given.
बेनिफिट तो साथ में आएंगे ना।
एक से ही होगा सर, अगर हम रिव्यू टीपीसी कभी भी करते हैं इस टीपीसी पे रिव्यू करेंगे तो एक से ही
इनको 1 जनवरी का बेनिफिट मिलेगा।
यस, लेकिन फाइनेंशियली लॉस हो जाएगा। फाइनेंशियली जो प्रमोशन के बाद 1 जनवरी से इंक्रीमेंट्स मिलने चाहिए वो नहीं मिलेंगे।
That also we get it.
सर्विस में कोई इशू नहीं है, सर्विस टाइमलाइन में।
Let a review DPC be done subject to, then it can be placed before the roster bench also.
Once we have promotion is given for first, pay benefit would also be get under FR22 from the same date only.
Because they are at the.
And this will be cover everyone, not only we, but them also. Lordship may keep the 1st January as an intact date and let the OAP decide it, because that protect everyone. We will also be get.
Showing about 1 January.
Because as on date, the original applicants, they do not have 3 years of today. If they can be promoted by the government, let them be promoted. But for that matter, stopping our promotion would not be.
Madam, you are looking at 5 petitioners. I am not looking at 5 petitioners. I've heard you. I've understood your point. Please, I'm not looking at 5 petitioners. I am also concerned by the petitioners who are Mr. Bharadwaj's clients. Okay?
Yes.
So that is also a concern in this court's mind. Please let us balance both interests.
Please.
Just take out. This is a petition filed seeking quashing and setting aside of the impugned order dated 23rd December 2024, passed in MA number 4862 of 2024 and OA number 1864 of 2023, passed by the CAT Principal Bench, New Delhi. The CAT Tribunal, by the impugned order, has directed the official respondents to not conduct DPC of the petitioners who were promoted to the post of tax assistant with effect from 14 September 2022. Stop. While injuncting the official respondents, the tribunal has noted that the final outcome of the OA would affect the placement of the seniority and grant of the correct year of appointment for the petitioners in the OA. Learned Counsel for Official Respondents states that the official respondents are willing to reserve requisite number of vacancies for the petitioners, and the same shall remain subject to outcome of the OA. Learned Counsel for the petitioners in the OA, Mr. Bharadwaj, states that merely reserving the vacancies would not be sufficient, as the seniority of the OA petitioners would also affect the seniority of the petitioner numbers 1 to 6 herein. He states that OA petitioners are at serial number 584 and 592 in the general category, and they would be placed above the petitioners. In reply, Learned Counsel for Ms. So-and-so, Learned Counsel for the petitioner states on instructions from petitioners number 1 to 6 that petitioner numbers 1 to 6 are willing to given undertaking that they will abide by the final outcome of OA number 1864 of 2023 and will not object to the seniority of persons holding rank of 584 and 592 being placed above them. She states, however, the urgency in seeking a review DPC prior to 31st December 2025 is that there is no dispute that petitioners number 1 to 6, right? Your petition number 1 to 6 are eligible for being considered for the post of office superintendent, and the date of 1st January 2025 is critical for the purpose of counting the year of eligibility service in subsequent promotions, as well as financial benefits associated with this higher post. She states that if the review DPC is carried out at a subsequent period of time, the financial benefits associated with the higher post will not be extended to the petitioners herein. Learned Counsel for Official Respondents states on instructions from, please give your appearance here, states that it is correct that petitioner number 1 to 6 will not be provided financial benefits unless they have been promoted with effect from 1st January 2025, though there may not be any loss of period of service. This court has considered the submissions of the parties. Thus, keeping in view the undertaking given by petitioners number 1 to 6, that they will not challenge the seniority of OA petitioners appearing at 584 and 592 in case they succeed in the OA. The order dated 16 December 2024 and 23rd December 2024 is modified to the extent that official respondents are directed to carry out a review DPC for petitioner numbers 1 to 6, subject to them filing an undertaking before the official respondent that they will not object to the seniority of the OA petitioners at 584 and 592 in case they succeed in the OA, as well as binding down the official respondent to their statement that they will keep available sufficient seats, sufficient reserved seats for implementing the decision in the OA. Just one more line in a star. Learned Counsel for the petitioner states that the order dated 30th April 2024, the final order dated 30th April 2024 has been recalled with a order dated 16/12/2024, and as on date there is no order operating in favor of the OA petitioners. He states that in these circumstances, petitioner number 1 to 6 herein, who are not even included as parties to the said petition, cannot be denied the right to be considered for promotion, considering that there is no dispute about their eligibility. And moreover, the non-denial of financial benefits is an irreversible benefit and cannot be extended even under the orders of the court. Anyways, list before the roster bench on so-and-so date. Review DPC will be carried out within 15 days. Okay? List before the roster bench.
मैम जैसे जो petitioner है इनसे सीनियर्स भी हैं काफी, तो उनके लिए भी रिव्यू डीपीसी करनी है फिर हमें, क्योंकि इनसे सीनियर्स हैं वो.
अगर वो अंडरटेकिंग देंगे तो ही ना, आप अगर अंडरटेकिंग देंगे वो होगा, क्योंकि वो इससे अफेक्ट होते होंगे. ये वाले जो petitioners हैं जो OA में हैं, अगर वो आपको दे देते हैं अंडरटेकिंग, then we can record that. आप उनको भी दे दीजिए, बट सब्जेक्ट टू ये आपको पहले अंडरटेकिंग देंगे तो ही आप इनका रिव्यू डीपीसी करेंगे. Madam, you want to address something on what he's saying? Who are the other petitioner, who are the other applicants who will approach them?
Because the other, as in the other people, the rest amongst the 150. Because they can also be promoted, subject to, because one thing
Madam, they will have to give an undertaking, so they will accept seniority, no?
That's true, but the seniority as on date has not been decided. So the undertaking has to be in terms of the language that they will abide by the promotions are subject to the outcome of the seniority as will be decided in the OA. Because that will be fair to everybody.
Well, it's one thing my friend is not correctly saying that financial benefit cannot be accorded. I can read out that OM right away. That says that once you are promoted, you will get everything from 1st of January. So it is not correct.
But that is the officer is saying that, Mr.
I don't know why he's saying that. I can read out that OM.
The officer is making a statement.
So he should not make that statement. I don't know why.
Salary, what?
ये OS था ही नहीं तो मैम हम उसकी सैलरी OS की
Listening, he's saying that, Mr. Bhargava.
That may be, I think he may be not aware of it. I don't know why he's making the statement. Plus.
Okay. Just say at this stage, learned counsel for the respondent states, official respondent states that there are 144.
I'm not sure, 144 to 45.
States that there are
approximately
145 other officers who are similarly placed, like petitioner number, who are similarly placed like petitioner numbers 1 to 6 and are similarly placed to the petitioner number 1 to 6. And he seeks clarification with respect to holding DPC for the said applicants. Full stop. It is clarified that if the remaining applicants who are eligible are willing to give an undertaking to Union of India, to the official respondent, to this effect that they will accept the seniority of the petitioner in OA number 18642023 as decided by the tribunal, then their request may also be considered in the review DPC list before the rosterment on 15 before 15.
Just one thing, because we are 1 to 5 petitioners, not 1 to 6. And Lordship has taken the undertaking, let it be on instructions. My clients are present.
Madam, you give an undertaking also. In addition, you will first give a written undertaking to them also. I have recorded your instructions. If you won't give an undertaking, they will not consider.
Very good.
See, they will give you also a written undertaking. It will come in the order. If they don't give you the undertaking, please don't consider the review DPC.
Because like the tribunal has rejected my impleadment. My impleadment may be allowed, so that my lords, when
now the matter will come up with the roster, then those all issues remain open. You consider it before.
Please.
Problem.
Anything? Give it in January.
23rd January.
7th was on the reopening.
Why, madam? Now the review DPC will be held, no, madam?
Very.
No, complaint.
Sir, concern.
Because I was only concerned about my lords any day before 29th. That is fair.
Give it before 29th.
23rd January.
Yes, 23rd
January.
Yes.
Grateful.
Because only thing is that when the seniority gets decided by the OA minutes, it may not be only 580, 84 minutes. So it should be this. The undertaking should be subject to the outcome of the seniority as decided in the tribunal. Because which, as he said,
Madam, he has pointed out it's 584 and 592. I have recorded that.
Because I only put.
Yes.
Please.
And if there is any, you want to suggest a language, you give it to the courtmaster. I'll consider it while settling the order. You just give the line. If it suits me and my brother judge, we'll make that change.
Very good. Because I'm so very obliged.
Leadership, may I mention a matter which I had mentioned in the morning? Leadership, this is a matter the Honorable Court had asked me to get the opposite counsel. The opposite counsel should be here. I requested the opposite counsel, Mr. Kashish Narang. He's the advocate on record.
Okay, I'll just reassemble. Then you just do that again. Okay? We just have another match.
Lots.
Hello, Courtmaster. Courtmaster. Courtmaster ji. Hello. Hello, Court Master जी.
Yes, madam.
सर कल बेंच बैठेगी ट्यूसडे को. हेलो. कोर्ट मास्टर जी. हेलो.
हाँ, जब तक टाइप नहीं होगा सेंड नहीं होगा तो कैसे
Uh, 17.
किसके लिए हो 13 है अब पूछ लो पहले पासवर्ड देंगे
सर 180 32 आइटम 15 है क्या
15.
आ जा ये भी भाई उसने मांगा हाँ हाँ It's happening in June. Should be easy then. Should be easy then.
कोर्ट मास्टर जी.
Yes, madam.
सर कल बेंच बैठेगी right?
पहले लेंगे ना
नहीं मैडम कल नहीं बैठेंगे.
अच्छा.
Item 13.
Okay, thank you.
Item 13.
13. Sir, item 13, I'm appearing for the Union of India.
Yes, madam. Online रहिएगा आप.
हाँ हाँ.
आप बता कर.
ऐसे चलवा देते हैं ये
Number 1 कौन है?
सर सर ये है
Medical Counselling. Ekta? Hello? Ekta, can you hear me? Yes, 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 I can hear you. You are appearing for whom? Union of India. Ma'am, I'm here. See, Arunima Dwivedi as a CGSE appearing for Union of India. Acha. Okay, this.
कोई बात नहीं दोनों रुक जाओगे
Who called you? Tell me. I got this matter marked on mail. When? 22nd.
हेलो जी
I'm appearing because I just got a call from Mukim ji. No, I got this matter. Actually, I was out of station, but I managed
एम
to.
के भारद्वाज जी वीसी में थे
Just call Mukim ji and tell him that what. Okay, yeah, I just now spoke to him. He did not inform me that he's informed another council. Yeah, just call him. Okay.
सर
क्या करूँ था?
पंखा होता है कि 2-3 जगह पे ना.
ये लो जी सर एक सेकंड में मैडम का भी सामान समझा रहा हूँ ले आओ प्रोनाउंसमेंट ले आओ मैडम को ले आओ मैडम
Ma'am, he's saying that he did not call Sangeeta madam, ma'am. इसी matter में item 13 में.
Himself has come to my chamber and asked me to remain present.
He said that you had come to his chamber, her chamber. He's now won't do it. हाँ मेरा वाला matter था. अच्छा ठीक है तो मैं क्या बोलूँ उनको? हाँ वो ऑनलाइन ऑफलाइन है मैं ऑनलाइन हूँ. हाँ
नहीं गया था मुझे नहीं पता इस मैटर में कहा है क्योंकि मेरे पास कोर्ट से ना सीजीएससी को कॉल गया था ताकि
अच्छा
सीजीएससी अवेलेबल.
ठीक है मैं बोल देती हूँ मैम. Ma'am, he's requesting that, madam.
I can hear you.
He is requesting that he will, because he had marked it before only to me. So he's requesting he to consider that.
बड़ा ही कंफ्यूजन है यार लाइफ में.
सीधे से लगा सिंगल में कर रहा हूँ.
So Shlok,
Yes, Leadership. This is a matter, Leadership, where I had requested the other counsel.
Yes, where is the
Mr.
other
Kashish.
counsel?
I have requested him twice. He's here now.
I am there, Milord. Am I audible, Milord?
Yeah, I can't see you. Yes, I can see you. Sir, please provide him with a copy of the petition. Please.
Milord, that has been provided. It has been duly
Please
recorded
provide it
also.
again, sir. Please provide it again. I'll take up your matter after 15 minutes. Just provide it again to him. Okay.
Milord, he's asking for the copy of the way he's not representing the client before DRT. Before DRT and DRT, both the copies have been supplied. So that is why
What
I'm
you
saying
do is,
that
counsel, I understand. You just supply it again to him. We'll take up your matter after 15 minutes. Okay.
I have no issues, Milord.
Mr. Shank, just take the copy. That's enough. Nothing more than that. Okay. Just have a look at the copies he gives you.
Very well.
Milord, I have no issues, Milord.
Leadership, if I get a clear copy, leadership, that's the end of the matter.
Yes, so
I will.
please, I'm sure he will give you a clear copy. Just have a look, okay? In 15 minutes, just do that. Yes, sir.
Very grateful.
It's 4 o'clock. We won't be able to do anything now. 3rd January, sir. So it will have to come on 3rd January now. This matter we've been holding court. I will not be able to go back and write orders for other matters, sir. We have to also write orders. 3rd January is the next date of sitting. It will be taken up on 3rd January. Okay.
Pronouncement of judgment in CS Commercial 626 of 2022.
Who's appearing?
Milords, I am Advocate Monica Goyal on behalf of plaintiff Milords and the respondent for the application.
Okay, Madam, I have allowed the Section 8 application and your suit stands disposed of.
Highly obliged, Milords.
Pronouncement of judgment in CS Commercial 733 of 2022.
My lords, I am appearing on behalf of the plaintiff.
This is Order 6 Rule 17, right?
My lords.
Yes. Madam, I have allowed the Order 6 Rule 17 application and the defendant has been given time to file an additional written statement. Okay.
Grateful, my lords.
Pronouncement of judgment in CSOS 488 of 2022.
May it please your leadership, I appear in this matter on behalf of the defendant.
Okay. I have dismissed your 39(1) and 2 and your IA by which you were seeking permission to build a porta cabin. I've dismissed that application and the court is putting you to notice on the maintainability of the suit. That whether the suit is maintainable at all. For maintainability on 13th February.
Obliged, your leadership, highly obliged.
Pronouncement of judgment in CSOS 223 of 2023.
Please, my lady, I'm appearing for the plaintiff in the matter.
This is the Abhinav Singh Ravish, right?
Please, ma'am.
Okay, the suit stands rejected.
Extremely grateful. Because the documents that I had filed originally from lordships can make a direction for that also.
Okay, just add a direction in this one. The original documents filed by the parties shall be returned to them in compliance with the rules.
Extremely grateful.
Pass over item number 13.
Madam, 4th passover in this matter because
Just informed.
Okay.
But ladyship, I just came to know that already union lawyer is present.
He's not come 3
Yeah, I'm
times.
appearing.
Madam, you be here now. Yes. Who's
Yes,
appearing
my
for the union?
My lady, I'm appearing for the Union of India. My lady, I apologize.
Thrice. The council has been meeting since morning 10:30 a.m. Madam.
I
Where were you?
apologize. My lady, I was out of station. My lady, I apologize for that. My lady, I was not aware of this matter being listed, my lady, today. I apologize for that, my lady.
Madam,
My
what
lady,
are
the
the
file.
instructions?
My lady, the file regarding relaxation of PG percentile is already under submission, my lady. And
Madam, are you going to begin the 3rd round counselling? When is the 3rd round counselling scheduled?
it is supposed to end on 3rd, my lady. But before that, we will know the exact status of the file. We will know the exact status when the file.
Madam, just wait. Madam, just wait.
Yes,
Please,
my lady.
counsel for petitioner. You were telling me the 3rd round counselling has to begin, right?
And we have sought extension, my lady, for.
Schedule was commencing from choice filling and subject choice is disabled in the system. In a way, choice filling of the both MDMS, DMP, whatever the it is disabled in the system.
So it is the effect is that it is not right now being processed. Madam, please tell me what do you want? We'll put it up before the roster bench. Then you just tell me that until then, the third counseling will not be closed, no? Because you know his case in this matter.
Yes, my lady, I have instructions to state that we will extend the third. We have already sought approval for extension of the third round counseling.
Okay, so extension of the third round counseling has been sought, so the matter can be taken up at by the roster bench at reopening, right, madam?
Yes, my lady. Yes, my lady.
Record
My lady can have it on second if my lady may please so.
Madam,
Because,
second court is not sitting on second. 3rd January is possible then. You want me to have it on 3rd
Yes,
January?
my lady may have it on 3rd January.
Okay, I'll record 3rd January.
Yes, my lady.
Just say, madam, you also give your appearance. We'll put both appearances. Then just say, learned counsel for the respondent, Union of India states that the third round of counseling is the period for the period for third round of counseling is the extension of period of third round of counseling is under consideration, and she prays that the matter may be taken up on 3rd January 2025 at request of the respondent. List on 3rd January 2025.
My lady, just one clarification, if I may
Yeah.
state so. My lady, the file is under submission for extension of the PG percentile, relaxation of PG percentile, my lady. So we will seek approval for extension of the, for counseling to be extended. That is why I'm praying that the matter may be listed on 3rd, because I will know the status of the file on the 3rd by 2nd.
So we will seek extension of time, you're saying, right?
Yes, we will accordingly seek extension. If it is approved, then the my lady, the writ becomes infructuous anyways. So if the it is approved by the minister, the writ will become infructuous.
Okay.
So,
okay, madam, just recast it, please. I'll give a statement. Learned counsel for the petitioner states that the file for relaxing the
yes, my lady.
percentile is under submission. Full stop. She states that subject to the decision on the same, the respondent will also seek extension for the third round of counseling.
Correct.
She therefore requests that the matter be taken up on 3rd January 2025.
Yes.
At request.
So the percentile is not reduced, then he will.
Okay. She states that since if the percentile is not reduced, the relief sought in the present petition may not survive for consideration.
Yes.
Madam, 4 sentences. Thank you.
Obliged.
Item number 15, writ petition civil 18032 of 2024.
So, where is the university?